Appeal allowed acquitted.
Deeply obliged.
Sir Bora,
Yeah.
we are allowed your appeal. Only thing, just double verification. If you ask your junior to go through the record, anything on the record of the court as regards disposal of the things, because the officer said we do not know, we have sent it through a salan. Any order, anything on record. Otherwise, we'll ask for an investigation, inquiry. That much I want. Allowed.
Public.
So therefore, it may take some time to dictate the last order. In view of the discussion and reason made herein above, the decision of the bid evaluation committee taken in its meeting held on 1/7/24 is set aside and quashed. Matter is relegated to the bid evaluation committee to take a fresh decision in terms of the determination made herein above and to proceed accordingly.
Obliged.
My lord, I beg to mention item number 63, my lord, supplementary list, my lord. My lord, in this case, my lord, petitioner file, my lord, a rejoinder affidavit. My lord, rejoinder is not in record, my lord. My lord, my humble prayer to call for a record.
Well, if I have a similar prayer in the same matter, I can respond number 3 to 5 also. ONGC, we have filed a reply to the IA. So Lakshmi kindly allow that to go. Obliged.
May I please, Your Lord? Lordship, with the consent of the other side, I beg to mention item number 26 of the daily list. Lord. In this matter, we need some time to file our reply. Lordship.
26. You have what?
Petition report.
You don't, what is this in this matter?
So I am instructed to mention, Lordship, I am appearing on behalf of Mr. MP Sharma, Lordship.
What is in this? You want to, well, but if we dismiss this petition, be ready for heavy cost. Yes, on the prayer of the learned counsel for the petitioner, this petitions on the learned counsel for the petitioner, matter stands adjourned and be listed on. Give a date. After puja. First of November.
Hello, Lordship.
30th of November.
May I please, Your Lordship? Item number 40, my lord. We have
Item number?
4040, my lord. We have filed an interlocutory application for implement of new incumbent, my lord. The matter may be taken along with the IA, my lord. We have filed interlocutory application for implement of new
Item number?
40, my lord, 40.
Where is the IA?
Today we have filed, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation.
May I please,
Okay.
Lordship, I beg to mention item number 32. Lordship, allow us 4 weeks time to file our affidavit.
On the prayer of the learned standing counsel for GST, matter stands adjourned and be listed after puja vacation.
Lordship, with prior consent of the other side, I beg to mention item number 23. Lordship, kindly pass over the matter for today.
Anything survives. Because in the meantime, this urban water is not there. Now they are coming with some new project. What is that called? Jalashakti. Water being installed through Jalashakti and this. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation.
I'll oblige. May I please, Lordship? I beg to mention item number 30 for adjournment.
Item number?
30. The engaged counsel is not well today. Engaged counsel is not well today. Lordship, can it be fixed on 20?
Anything survives as on date?
Lordship, I'm not the engaged counsel.
Oh, we will not adjourn this matter. Notices were issued. You appeared before you have not been arrested. Affidavit has been filed stating that all these facts are incorrect. How can we decide? You have not filed reply till date.
Lordship, can it be fixed on 25th of this month?
We do not appreciate this kind of things. When matter is, the lawyer knows that nothing survives, you take an adjournment. Wait, but ready to pay cost. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation. If it comes before this court and if we dismiss it, ready to pay heavy cost. Yes.
Hey, Your Lordship,
Yes.
I beg to mention item number 28, Lordship. In this matter, we need to file our reply, Lordship, after vacation, Lordship.
On the prayer of the learned counsel for the petitioner,
P. Boardley, Lordship.
P. Bordole, matter stands adjourned and be listed after vacation.
Reply.
Very unfortunate.
Can it be taken up after some time?
An officer is here only for non-filing of it. We do not want a responsible officer to be here. See, we expected that he will file an affidavit so that he need not come.
We have received the instruction, but we have missed the deadline.
Then for that the office, he is the officer. Yes, please come forward. You are a secretary.
Principal Secretary.
See, think of it, a principal secretary is here only for the fault of your lawyer. See the situation. We never want a responsible officer to stand at 10:30 in the court, leaving aside his job. When we pass this order, on 2/9 we have passed this order, and we say that affidavit be filed till today. You could not even file the affidavit today, and officer is here. See? Yes, what do you say? See your inefficiency of either of your officers sending to this information to the lawyer, or inefficiency of the lawyers. You are a principal secretary, you should act.
Apologize. Information has come only on 20th, so that is why.
Think of it, we passed this order on 2/9. You remove this, whoever is responsible, remove this. This is not the way. Do we feel good looking at the principal secretary standing here?
We apologize, ma'am.
We want in whose fault this affidavit has not been filed. And we'll pay cost, maybe lawyer, maybe officer. Will not blame principal secretary. This is not his job to look into. And from the pocket, we'll have to pay. That's what you say. See, this is the situation, what is going on. This is not the only case. Well, sorry to say, absolute inefficiency. You had 3 days in between, Saturday, Sunday. You could have filed, you could have said that we are filing during the course of this day. I was surprised when I was informed that somebody is sitting in the court. I was surprised. I thought that at least they will file this during the course of this day. Whose fault? Please file an affidavit. Whose fault? This court, under its order dated 2/9/2024, asked the petitioner, asked the respondents to file an affidavit in terms of this court's earlier order dated 30/8/2019. Full stop. Though an affidavit was filed on 5/9/2019, such affidavit did not disclose anything in terms of this court's earlier dated 30/8/2019. Considering the long pendency of this matter, this court, long pending the pendency of the matter and the importance of the issues raised by this court under its order dated 30/8/2019, reluctantly allowed time to the respondents to file affidavit and was directed directed this matter to be listed on 29/3/2024. To assure that an affidavit is filed, an observation was made that if such affidavit is filed uh, affidavit be filed on 29/20/24. Full stop. However, no affidavit has been filed till date. No. File be to 29/20/24, and in the event such affidavit is not filed, this court further directed the personal appearance of the principal secretary and the commissioner and secretary of the government of Assam Revenue and Disaster Management Department. Full stop. Unfortunately, till date, no affidavit has been filed, and therefore the principal secretary to the Revenue and Disaster Management Department is personally present in this court. The principal secretary submits that they have received the intimation only on when?
20th September.
20th September 2024 from their counsel, and therefore they could not file affidavit within.
Kindly pardon me, sir. It is the information we received from the district commissioner, whatever information we had asked for preparation of the affidavit, that information has come on.
Okay. Come on. Full stop. The principal
counsel
secretary submits that the department in the information in his office was received from the concerned district commissioner only on 20/09/2024, and in that position it was not possible to file an affidavit on the date itself. Accordingly, the affidavit could not be filed. This is the case. Full stop. In the aforesaid backdrop, this court prima facie cannot held the principal secretary responsible for not filing of the affidavit. However, it must be assured. However, this court would like to have the complete instruction under what circumstances the order dated 2/9/2024 could not be complied with. Accordingly, you will file the affidavit, or who will file the affidavit detailing the stages when you have received, when it goes to the commissioner, and when to the principal secretary.
Yes.
Who will file? Let him file.
He will file.
Okay. In this regard, the principal secretary submits that he will inquire into the matter and file a detailed affidavit, explaining the delay in furnishing the information in his office. In view of the aforesaid, the personal appearance of the principal secretary is dispensed with. When will you file affidavit?
Within this week.
Huh?
Within this week.
It is submitted that as the instruction has already been given by the office of the principal secretary, the learned counsel would be able to file the affidavit in terms of the order dated 2/9/2024 and order dated 30/8/2019 within this week. Accordingly, matter stands adjourned and be listed on next Monday. Next Monday is a working day. 30. Put it on 1st of October. Please look into. This is not the way cases are done. And district commissioner should also be. We understand he's a busy person, but this is a matter pending since 2019. And even if we get the information, this may be a case for dismissal even. We want that information. The affidavit file in the 2019 is nothing but a storytelling. Have you gone through it?
Yes. No material.
Nothing. What material? Yes.
Apply.
Please ask your advocate general also that this does not happen.
My lords, for implement of these applicants, as the respondent number, my lord, 6, 7, and 8.
What is the issue?
Lord, I would like to file a short objection.
Okay, let us understand the issue.
Issue is this: the garden was sold in auction.
Hmm.
Now the respondent number 5,
Hmm.
he has purchased it at rupees 32 crores. Out of that, my lord, Provident Fund Authority, they had their claim 4 point some crores. And then Punjab National Bank 6.5 crores. That was allowed to be given to them. But for others, by this honorable court, your lordship, can we see the order passed that in regard to
Give the
others
repetition.
at page 16, my lord, of my IE.
Okay.
At page 18, your lordship will find
Yes.
1/8 million. The last para, in view of the projection made on behalf of the petitioner in the aforesaid manner, this court is of the considered view that till the returnable date, the respondent number 1, who was the custody of the amount realized, that is, my lord, realized pursuant to the auction sale process, shall not disburse any amount to any other third party, save and except realizing the statutory dues of the respondent number 1 and the respondent number 4. There is a Provident Fund Authority and Punjab National Bank.
Who are you?
I am the workers of the erstwhile garden, my lord, who has been auctioned. So, my lord, we have our
Salaries and all.
yes, salary and provident fund and all these things amounting to rupees 21 person will get 25 lakhs, another will get 15 lakhs. And these are, my lord, and one of the person, my lord, he is in the deathbed. He had a stroke.
Yes. What is your objection?
But your lordship has seen what the order is concerned. But what has happened in this case? But there was a due of 4 crore by the bank and 4 crore around PF. But they had initially auctioned our one of the gardens for where the reserve price was 26 crores, and which was not no bidder has come. Thereafter, they added more 2 gardens to it, and the reserve price was made 21 crores. But they have also flouted the auction process. That is the main subject matter of dispute. And we say that now the balance amount is with PF. If they distribute it, my lord, then my lord, the otherwise indirectly it's a confirmation of the my lord sale, my lord. And which is the subject matter which your lordship would be deciding.
No. So, okay, fine. You are not considering the vacating of the interim order. They are, by virtue of this interim order, they are an affected parties. So why they will not be a necessary party? What objection will you file?
Lord, in fact, your lordship.
Please,
see that,
Mr.
my lord, yes. My lord, your lordship would see one of the applicant is an employee of respondent number 7, who is the my lord taken over the.
Can we go to the merit of a case in case of implement if prima facie satisfies that they are?
Lord, your lordship, in spite of your lordship's direction, the respondent number 7 has not filed affidavit as yet.
That is a different. We are not on that. We are on the IA. Tell us on that.
And lordship may admit them. Lord,
That is what we are asking. Why should you go to the
think
merit?
that my concern is Lord.
Your concern will be taken up when the affidavit shall file matter are decided. We cannot, at this stage, we cannot enter into the merit and comment. But Mr. Counsel, we will have to shorten certain things. Those good days are gone. That will take times, days.
We have also
on,
reasons,
on,
my lord.
on restoration petition,
Due respect to your lordship,
on
my lord.
restoration petition, on IA for implement.
Lord, the timing of the application is also
Maybe
relevant. Lord.
timing of application is not important. Timing of application will take if we know that they are, we may dismiss their claim.
That lordship will decide.
Heard Mr. Dr. Larned, Senior Counsel, assisted by S. Musahari. Also heard Mr. R. Dubey, Learned Counsel for the writ petitioner, and Mr. Das for the
Party number 3 and 4, your
3 and 4. He will be opposite party number
I 1 and 2, my lord.
1 and 2. Yeah. The present application is filed.
My
Implement of
friend
the
will also
applicants.
represent 5, my lord, I think.
Application praying for implement of applicants as party respondents in the connected writ petition, that is WPC 6459 of 2023. The subject matter of dispute is the auction, sale, and purchase of the tea gardens belonging to the petitioner, belonging to the petition that has been done by the respondent number
My lord, 3, 4, and 5.
3, 4, and 5. Full stop. The present applicants claims to be the employees under the garden, full stop. This court, under its order dated 10/11/2023, while issuing notice of motion, directed, provided that the custody of the realized custody, observe that the purchase sale money obtained in the auction shall not be disbursed to any third party save and except the statutory dues of the respondent number 1 and respondent number 4. It is the case of the applicant that they are being employees of the erstwhile garden. They are also having some claims, and by virtue of this interim order, they are deprived of their rights. Full stop. In view of the aforesaid contention raised, in the considered opinion of this court, they will be a necessary party for determination of the necessary party, in as much as any determination made may affect their right also. Full stop. Though Mr. Dubey learned counsel tried to impress upon this courts by entering into the merit of the case, in the considered opinion of this court, at the stage of this implement application, this court need not go to the merit, in depth, and a prima facie satisfaction is required. Accordingly, in view of the reasons recorded herein above, the present application stands allowed by impleading the present applicants as respondent number
6, 7, and 8.
6, 7, and 8.
In
Six-
WPC number
6, 7, and 8 in WPC number 6459/2022. MS S. Musahari, learned counsel, shall prepare an amended cost title in terms of the cost title of WPC 6459/2023 and the order passed today, and furnish the same before the registry within a period of 5 days from today for appropriate correction that is to be done by the registry. Full stop. MS Musahari shall also furnish the amended cost title accepted by the registry to the learned counsel for the contesting parties, so that they can also correct their records in accordance with the order passed today. I stands disposed of.
Senior counsel, Mr. Das is there online, Lord, representing.
Okay, Mr. Das, senior counsel, and Das, and she does.
3, 4, and 5.
3, 4, and 5. Assisted by Mr. A. Deep level, yes.
Obliged to close.
Yes, just a minute.
I have gone through that.
Uh.
Though there is an order by the trial court
Uh,
for disposal on 10/5/2022
Mm.
to the Delhi police station
Mm.
to take necessary action
Mm.
for the disposal of the all contraband.
Mm.
But subsequently there is no report
Mm.
whether it was actually disposed of or not.
Okay, just give a flag mark of that order.
There is a direction to the
Ah,
Delhi police station.
Now, two things, there is a direction.
Yes.
One says that I have sent it, and it says it is in the delay. So there is inquiry is required from both the side. I think so.
Whether the police has subsequently
Yes. So
complied with
therefore, we will, in my mind is we will ask the Director General of Police to make an inquiry, as well as a report through the register vigilance from the concerned judicial ministry.
because there's a direction to dispose it of after receipt of the FSL report within 30 days. That is on 10/5/2022. But thereafter, whether it has been actually disposed of or not,
That is not.
there's nothing.
Please ask your junior to flag mark it.
All right.
So therefore, we may get it uploaded in the evening only.
Fine.
Orders.
May it pleases your worship, service is completed on all the respondents.
In view of the office note dated 8/8/2024, the matter is ready as regards service. Accordingly, list this matter in the admission column. When? After vacation.
Yes. There is an interim order.
Interim order pass earlier shall continue till the next date of distribution. Yes, forest, where is forest? Always forest. PHC is to be invited. Hi, Botapur. What is your case?
My lord, in this case,
Wait for some time. Yes,
Lordship,
on invitation only.
no, Lordship, I wasn't like, Lordship.
Yes.
The issue is here, Lordship, this matter was.
No issue we do not know. On last two occasions, you have
Yes, sir,
taken
Lordship.
time
We,
to
even we have communicated with the engineer, Lordship. He said that they're not being able to trace the technical section administrative approval. Even they have written letter to the petitioner seeking if he can come up with something, so they can make a refund demand. Since even the petitioner doesn't have the document, Lordship, we approach the higher authority to submit the same so that we can make the same fund demand before the authority, Lordship. That's the issue we are facing because the work orders of 2005-6, Your Lordship.
So when can you file this updated affidavit?
Lordship, let it come after 2 weeks, Your Lordship. I'll file an affidavit, Lordship.
Okay, Mr. Gogoi submits that due to the, for the reason, not due to, Mr. Gogoi submits that for the reason that the records of the case and the claim pertains to the year
2005 and 6, Your Lordship.
2005 and 6, they are not finding some important document for compliance of this order, and the petitioner has also intimated to them that petitioner is also not having the said old
Yes, sir.
document. Therefore, they may require some more time to complete the process for compliance of
Yes,
the
sir.
order in question. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter in the first week of November 2024. Itu কি? Yes, what is this?
Lordship, I am seeking an adjournment for today. Lordship, Mr. MP Sharma was conducting the. Mr. MP Sharma was conducting the case. The file is with him. Lordship,
What is what is this case?
We have canceled the advertisement
Advertisement means what
for
advertisement?
distribution
Huh?
of dealership of LPG distribution. We have canceled the advertisement.
To cancel is cancel. Matter is there.
I do not have the file. While coming down, Lordship, while coming, he suffered an accident. So, Lordship,
Suffered an
he
accident.
fell down from this.
Okay, it is submitted that Mr. MP Sharma, Learned Counsel, for the applicant has met with an accident today, and therefore an adjournment is sought for on his behalf. Prayer is not opposed. Accordingly, list this matter after vacation. What is the IA?
Interim order, if I'm.
Huh?
Lordship, I'm told that
There-
interim order as well.
What interim? You have cancelled it. At what stage?
After FBC, madam. Field verification credential, madam.
So you have cancelled entire.
Yes, madam.
What can we do? If they say that no, under this area, in this land, we cannot do this. Then what can court say that no, you'll have to do this? That's all.
There is no Gampansar in Tabiangan area, madam. So he has inserted, he along with the other applicant inserted as a Gampansar. So we have canceled the entire.
Till the next, the interim at least.
What interim?
There's an interim order, I'm told.
To do what? To not to do what?
Not to cancel.
You have already cancelled.
No, we have decided.
Cancel it.
Yeah, yes, we have canceled.
You proceed. You will be at liberty to. Okay. Otherwise, you are not interested in
Yes.
that. There is a stay. Let it remain. When?
Need it.
First week of November.
Oblige.
The order has been passed on disposing of. Okay. Okay, I didn't.
What is your decision?
The claims, my lord, made by the petitioner, my lord, regarding T, those are not, he's not,
So according to him, he is entitled for 194,
yes, whatever
160.
he has been paid, my lord.
Okay, where is that? Where is the order?
Order, my lord. It is in the,
Order passed by this court?
yes, my lord, page 11, my lord.
Yes, from 9, 11.
11, however, the last paragraph, however, considering the only direction was to consider the representation, my lord.
So we have this, you go through it and we are closing it.
I have to take the instruction.
No, you need, for closing, you need not take instruction. You will have to take instruction whether you will challenge it or not challenge it. According to us, we are satisfied that no contempt.
I have to
You
go
take
through it.
instruction, we are permitting that.
Yes.
The present contempt petition is filed alleging willful and deliberate violation of this court's order dated 17/3/2021 passed in WPC 2933/2011. By the aforesaid order, the petitioner was directed to file a fresh representation indicating his grievances herein and to seek redressal thereof. The petitioner was permitted to file such a representation within a period from 1 month from 7/3/2021, and the board, Assam Khadi and
Village Industries.
Assam Khadi and Village Industries Board was directed to dispose of the representation within 2 months from date of receipt of the same.
They filed on 16/12/2021.
Such representation has in the meantime been disposed of by an order dated 21/9/2024. 2024. In view of the aforesaid, though there is a delay in disposal, however, considering the fact that the representation of the petitioner has been disposed of, this court is inclined that this court is of the opinion that the order dated so has been complied with. Accordingly, the contempt petition stands closed. However, the petitioner shall be at liberty to assail the order dated 21/9/2024, if so advised. A copy of the order dated 21/9/2024 is kept on record and marked as document X.
Okay.
Order has been complied, Your Honor. Order has been complied, Lord.
None appears for the petitioner on call.
I'm providing the Lord.
Mr. M. Bhagavati,
For
learned
respondent number
counsel appearing for respondent number 2, and Madam,
Lordship, for respondent number 3, Mr. D Nath is appearing.
Mr. D. Nath, learned counsel for the respondent number 3, and Mr. A. Das for respondent number 1 jointly submits that the order dated 26/10/2021 passed in WPC number 5792/2017 has been complied with. Full stop. Mr. Das has also produced a copy of the order of compliance, which is kept on record. Order of compliance dated 16/2/2023. The same is kept on record. Full stop. In terms of the aforesaid order, the ex gratia payment has already been made to the petitioner. Accordingly, the contempt petition stands closed. A copy of the order dated 16/2/2023 is kept on record. None appears for the applicant on call. Service is complete. However, none appears for the respondent to object the present application. The present application is filed any IA? Huh? Application for condonation of delay of 46 days 46 days in filing the restoration petition against the restoration petition of WPC for restoration of WPC 7053/2019, which was dismissed for default on 26/2/2020. In the considered opinion of this court, Limitation Act shall not be, law is by now well settled that the Limitation Act shall not be applicable in case of writ petition when the same is dismissed for non-prosecution, and the restoration is to be considered on the merit of the case and can be restored, and delay can be condoned if the delay is not unreasonable, and such exercise can be done under such order can be passed in exercise of this court's power under Article 226 of the Constitution of India, which is plenary in nature and not controlled by the provision of the Limitation Act. In view of the aforesaid, the IA 1393 filed for condonation of delay stands closed. However, it is recorded that the delay has properly been explained. IA close, 1393 closed. The present application is filed under Order 9, Rule 4 of the Code of Civil Procedure. Not necessary. Is filed for restoration of WPC 7053/2019, which was dismissed for default within bracket non-appearance of the learned counsel for the petitioner by an order dated 26/2/2020. None appears for the petitioner on call. However, in the interest of justice, matter stands adjourned and be listed on Friday. Listed on Thursday. Let us see whether anybody appears. Yes, 26th.
May it please your lordship. Your order complied.
Learned counsel for the petitioner submits that the order dated 9/3/2023 passed by this court in WPC 4607/2022 has already been complied with. In view therefore said, cut the Mr. A. Das,
Respondent number 1, Your Honor.
Mr. A. Das, learned counsel for the respondent number 1 is present. In view of the aforesaid, the contempt petition stands closed.
Oblige, Your Honor. Oblige.
This matter may be taken up on Friday, my lord, if request, because matter pertains to Anne Haveli. She has some personal difficulties today.
We are
On Friday.
dismissing this for want of steps.
Yes, yes, my lord.
For want of steps, we are dismissing it. Forget about
Steps.
Riley. Yes.
Is it 46?
Yes, you were in this matter. Or maybe,
How many respondents are there?
is it so?
Yes.
But some problems.
I have now filed wakalatnama in this matter. We appeared in the last.
We are not informed, my lord.
Who will inform you? You are the petitioner.
Yes, my lord.
Who will inform you? You don't have any time to go through the order sheet.
The interim order is there.
We'll vacate everything. If you don't have time to go through the order sheet, then we are vacating everything.
There is no such interim order. In fact, it is in against the attachment of the bank accounts that we have principally come.
My lord,
Who are you, Mr.
I have subsequently filed wakalatnama minutes
467.
for this petitioner minutes in item 46.
Have you taken no objection?
So the notice was issued. Notice was issued to them.
By the client.
I'm not aware of that, because I have been instructed.
This is very unfortunate.
Yes.
It reflects very bad. Steps.
Look, steps.
How many respondents are there? Tell us.
Six.
Six
Huh?
respondents are there.
What about 5 and 6?
Your Lordship, I am for. He's appearing for 6.
And who is 5?
5 is the State Bank.
You are 6 means
Yes. State Bank Limited. Yes.
who is the first State Bank? No steps have been taken.
Look, as far as State Bank is concerned, though it's the pro forma, I'll take steps on State Bank. No difficulty, Manoj. Earlier the steps were
No,
taken.
there is no difficulty, I understand, but you have not taken.
Here, Manoj, what has happened is that there was some lack of
Miscommunication, yes.
communication between the
Maybe.
petitioner. Petitioner is suffering from some neurological problems.
That's
Because of
what-
that, Manoj, there was some appears to be some miscommunication between the earlier set of
Okay.
counsel.
It is submitted by Mr. Ganguly that he has recently been engaged by the petitioner to represent the petitioner. However, Mr. MS Gogoi submits that she is not aware that the N. Gogoi, who is representing the petitioner, submits that she is not aware of such development. Accordingly, matter stands adjourned and be listed after puja vacation.
Can a date be
In the
fixed?
meantime,
Can a
no,
date-
in the meantime,
The difficulty is bank accounts have been attached for the last 1.5 years.
we understand, but no steps have been taken.
That was.
In the meantime, the petitioner may take steps for issuance of notice upon respondent number 5. Full stop. No need for issuance of notice in respect of respondent number 6, as Mr. M. Sharma has entered appearance. Full stop. List this matter on give a date. After vacation.
Okay.
21st of October.
Gotcha. Lovely.
This application was for non-payment of the admitted amount for the
Ah.
supply of materials of the MG and Rega.
Hmm.
Page number 6 was the order, my lord. And relevant paragraph, page number 8.
What is your stand?
I filed affidavit.
What is your
my
stand?
lord. The order was to, my lord, to verify and pay, my lord. If admissible by the state, then and pay, my lord. My stand is that, my lord, during the, my lord, the work, my lord, there is a procedure before the completion of the word, my lord. In running time, the video has to upload the bills in the system. Otherwise, that way, after closing the, my lord, work, my lord, video cannot upload the further, my lord. Therefore, regarding the liability of the state, my lord, the fund is come from central government, my lord. Although video has admitted, my lord, but in the state, my lord, we cannot admit because those were admission was made after the completion of the work, my lord.
Now, who will compensate? Forget about the bill.
In similar matter, my lord, We have wrote to the government of India, my lord. I can produce that, my lord. Thereafter, government of India allowed us to reopen the, my lord, the app, my lord, the MIS, so that we can upload the bills, my lord.
So you do it here
So
also.
in this matter also, I am praying for similar sometime, my lord, so that we can approach the government of India.
Okay.
After the
The
vacation.
claim of the petitioner relates to non-payment of bill,
Contractual bill.
amounting to rupees
76 lakh, my lord.
76 18 804. Full stop. An affidavit has been filed by who filed this affidavit?
My lord, commissioner, my lord, deed and commissioner.
An
Now it's transferred.
affidavit is filed by the commissioner,
Panchayat and Rural Development.
Commissioner, Panchayat and Rural Development Department, taking a stand that though the block development officer,
Page 19 may be seen, my
page
affidavit.
19, na? Block development officer block development officer tried to upload the bills of the petitioner, admitted bills of the petitioner. However, due to the upload the bill of the petitioner in the system, however, the system did not permit such course of action for the reason that the bills were required to be uploaded during execution of the work.
Real time.
Execution of the work on real-time basis.
Yes.
Full stop. The learned counsel for the petitioner further contends that the such execution of work is financed by Union of India. Therefore, system is so programmed that subsequently such bill cannot be uploaded, and therefore the state is not in a position to make payment in absence of issuance of in absence of uploading of the bills on real-time basis. He further submits that in similar circumstances, the state sought for permission from the competent authorities in the Union of India to allow uploading of the bills at subsequent time which were allowed. Therefore, the state respondents are pursuing with the Union of India, and it may take some time, and accordingly a prayer for adjournment is made. Full stop. The learned counsel for the petitioner also prays for an adjournment to respond to the affidavit filed by the commissioner. Full stop.
Well,
Accordingly,
more, my lord. The commissioner, my lord, was transferred in the.
That transfer, let it remain.
Right.
In view of the, it is also submitted that the respondent number 1,
Sole
respondent has in the meantime transferred, and a new commissioner has joined the office, namely
J. Kirti IAS.
J. Kirti, KIRTHI, Kirti IAS. Full stop. In the aforesaid backdrop, the learned counsel for the petitioner prays for some time to file a response to the affidavit, as well as to file an application for implement of the new applicant. Prayer stands allowed. This matter in the second week of November 2024. But you cannot straightway come. You will have to intimate Kirti Jali that this is the order, this is how, otherwise we will not allow impediment.
My lord, in the last part, my lord, it was a submission of the respondent.
Yes.
That
we have it. That will be corrected.
Obliged.
Petitioner respondents will be done in the chamber.
Obliged.
That instruction Lordship will take it, or I will back.
You take back. Just this is a submission. We will not make it a part of record.
We are trying our best, my lord. Obliged.
But at the same time, if you are trying base, at the same time, things should not happen that no work is executed, subsequently bill is prepared and uploaded.
That is why, my lord.
No, we will not appreciate this.
My lord, yes.
My lord, in the affidavit, it is.
No, we do not know. You have worked, if you do not upload, we have seen.
Yes.
In fact, we have seen while working in High Court also. Real time, they will have to not only upload bill along with the photographs with GPS location.
only this is the reason, my lord. That is why if
We
BDO
do not-
accepts
That's why
also,
we are not commenting
cannot-
anything. It's up
yes,
to
we
you.
cannot admit, my lord.
And in
Yes.
this case, my lord, the supply of materials only, not my lord, execution of the work, my lord.
Maybe.
They admitted.
Moment supply is received, you'll have to have a bill. Ultimately, when you pay different thing, with the location in which godown you have given and upload it. Ministry monitors it. And then this is the suppose you take a photograph in the godown itself of the seller, he gives you a false bill. Will it do? Then
48, my lord, order complied, my lord.
none appears for the petitioner on call. Mr. Dutta, learned counsel representing for respondent number
Respondent number, my lord. 1, 2, and 4.
1, 2, and 4.
5 and 6 also, my lord. 4 and 5 and 6, same person, my lord.
Okay. Appearing for the respondents submits that order dated.
The petition I don't have, my lord. Only a compliance order I have.
Just a minute. Order dated.
Direction was for demarcation, my lord.
Order dated 24/1/2024, passed in WPC 7368/2023. Whereby a direction for has been complied with. Full stop. The petitioner has also submitted and this is in Fazul Haq, is not it?
But yes, my lord.
Fazul Haq.
Fazul Haq.
And also it is full stop. And also submitted that an amount of rupees 63,667 has been reimbursed as financial loss incurred by the petitioner due to the Thing Municipal Board's occupation of area that belong to Botodrawa Ansolik Panchayat. Be that as it may, as none appears for the petitioner on call, the contempt petition stands closed for non-prosecution.
Obliged.
My lord, in item number 49, my lord, I am appearing on behalf of respondent number 4, my lord, newly imputed respondent. So we may be allowed to file affidavit, my lord.
Earlier occasion also they have.
No, on the earlier occasion we appear, my lord, for the first time.
My
My lord,
in this
regarding-
case, I have filed one IA. Illegal construction by the vessel number 4. Lordship.
What is this?
This is for demarcation of the railway land, Lordship.
My lord, no
And
copy of the
government
IA has been
filed
served to me, my lord.
Till today, Lordship, 2022 May time. But
Railway land, Rongya.
Gorpando area. That Maligaon Gorpando area, Lordship. Whole lands are occupied some parcels, Lordship, 63 acres of land.
You are for?
My lord, I am for newly imputed respondent number 4, my lord.
Who is deliberation for?
My lord, private respondent number 4, my lord.
What is your business?
Because he has, I have included him, Lordship, he has started construction over the railway land. And
He has started construction over the railway land. You are the railway.
the circle officer also issued notice to him
Ah.
to stop the construction, Lordship. So he has not stopped the.
We'll demolish it.
My lord, let me
That
submit,
is-
my lord.
Lordship.
Now, in the
That's
writ
why I
petition, my
filed
lord.
the- Even after the circle officer has issued the notice, he started construction and.
Yes, circle officer is a party in your writ petition.
Yes, he is a.
What is his affidavit?
Government has not filed affidavit.
That acquired land here also. What is
There
your
is a
state?
dispute between the
Railway?
regarding that land between the state and the railway department. Accordingly, Lordship, a stop construction notice was issued to the private respondent number 4, the newly imputed. Now, according to them, Lordship, he started construction on that property.
No, tell us, according to you,
Lordship.
land belongs to the railway or to a Prata land?
Lordship, no,
Demarcation has not been done, Lordship.
yet to be done. Lordship. It's not a Patra land, but because of that dispute, the private respondent number 4 was directed to not to construct.
Yes.
Okay.
A notice was issued to him.
Now he's still continuing the construction.
According to them, it's as because it is under their occupation, lordship.
What is the construction?
My lord, in the writ petition, their claim is that in 1963, the railway acquires some 63 bighas of land for Brahmaputra bridge construction. My lord, that is, my lord, yes. Now, my lord, I have a document, my lord.
All are illegal.
So, that land belongs to my lord, dark number 44. Already that dark has been corrected. Now, in their writ petition.
That is the corrected when?
Yeah, my lord, I'll come to that. In their writ
First
petition.
tell us corrected when?
No, my lord, I have the documents, my lord.
No, you have the document. I'm asking you a question. Corrected when?
No, that instruction was there. My lord,
That is the final
yes,
instruction.
No, my lord, what happened? In their writ petition, their prayer is for correction of records. And earlier, when
there are two correction of records. I'm telling you. One correction of record that has been done at your prayer. That's why I'm asking what is your record, date of record. And other correction of record is according to them that your correction was wrong because land was already acquired.
Yes, but that acquired land.
Now, how an acquired land can be recorded by the circle officer in your name?
This is my inherited land, my lord, patta land.
No, your listen.
Yes.
The gamut and sum and substance of the case is this. According to railway, we acquired this land long back, 50, 60 years back. When?
63.
63. Acquired this land by paying
Yes.
land acquisition compensation. Land acquisition compensation
I have annex
to the landowners. Then it continued. Subsequently, and record was also corrected. Then subsequently, during settlement operation or whatsoever, that rent was recorded in your name.
Many persons.
Now railway says, please correct this record. That's why I have asked, what is your date of correction of record? And what is the date of record? Don't construct.
No, my lord, already one suit has been pending before the civil court in between railway and the private.
Therefore, you don't construct.
My lord, that order may be there, my lord. Only thing is that I may be allowed to file, my lord, affidavit in these writ petitions and let them, my lord, directed to start a copy of that IA, my lord. Till they not supply this
Okay,
IA.
give a copy of IA.
Because, my lord, I am appearing for the, on the last occasion we have
file.
appeared.
Mr. Sharma,
The construction may be stayed, lordship, as because our notice
No, my
is
lord, till
already
that,
there.
my lord,
Our
till
notice
that,
is
no,
already there.
copy has been served to me, my lord. I am
But notice is already there.
my lord, my prayer is, my lord, as per my instruction, my lord.
have you challenged their notice?
No.
Well, already suit has been pending, my lord, before the trial.
No, tell us. Have you challenged the
regarding
notice?
that notice, I have.
Have
no
you
instruction,
made
my lord.
file an application in the injunction
My
application
lord,
in the suit?
my lord, fix a short date, my lord. I may be allowed to, my lord, submit all the documents regarding this land.
Lordship.
Because, let me finish. My lord, I am, my lord, possessing my land, which has belong to dark number 40, 41, 42, and 43. Now they are claiming 44.
Have you filed affidavit?
No, my lord. Let them file.
No, lordship, we will file affidavit, but lordship, let him.
My lord, I have filed a suit.
Affidavit, lordship,
Yes.
the IA, let the IA be exchanged. But in
My lord, I may be allowed to
the-
file.
the
No, we are
same
not.
may be there.
See, we'll demolish it. We'll allow you to demolish it.
No,
If it is
no,
a railway
no,
land,
my
he is doing at his own risk.
Yes, my lord,
We are not on
already
that.
I have filed a suit saying that, my lord, some part of my land is enclosed by this railway. And in that suit, my lord, they are participating, my lord. And now they have filed this petition, my lord. In IA, my lord, they are never served this. Let them submit copy, my lord. I may be allowed
It is
objection, my lord.
submitted by the learned counsel for the respondent number 4.
Oh.
That copy of IA has not been served upon him. Accordingly, he prays for an adjournment. Prayer is allowed. The learned counsel for the writ petitioner to furnish the copies of the writ petition. Writ petition you are having?
No, no, yes.
Copies of the IA to the. There are some judgments in this regard. Earlier judgments. Mr. Sharma is aware.
My lord, earlier one judgment is there, my lord.
In this case, Sharma is here. Sharma is aware.
Judgments are there, lordship.
Shall furnish a copy of the IA to the learned counsel for the respondent number 4 and list this matter on after vacation, not before. 29th of October 2024. The IA shall be considered on that date. In the meantime, let the state respondents also, more particularly the revenue authorities, shall also file their affidavit, inasmuch as it is the revenue authority who has issued a stop construction notice to the petitioner, and the dispute revolves around whether the land in question belongs to railway or to the petitioner. Full stop. On the aforesaid aspect, a neutral view can
Railway or to the respondent of.
respond number 4. A neutral view can be taken considered on when an affidavit is filed by the revenue authorities. List this matter accordingly.
Lordship is fixing it on
29th of October
October.
or first week of November.
Lordship.
First week of November.
My lord.
Give a date.
If-
After 10, 8, 9, 10, like that.
Obliged.
Whose typographical error? Court's or yours?
Lord, both sides, my lord.
What both sides?
My lord, in our petition, my lord, our father's name was wrongly typed, my lord. And in the order sheet, my lord, my name is wrongly typed.
What was the case?
Case, my lord, regarding, my lord, allotment of, my lord, petrol pump, my lord. In the first lottery, my lord, he was selected, but during land verification, his land was found not suitable.
Who is he?
The writ petitioner, my lord.
Okay.
Writ petitioner, my lord.
Then
Thereafter, my lord, in second lot, I have been, my lord, selected.
where is the order? Where you want a type of correction of typographical error?
IA 2221. IA 2221.
I am, my lord, page 11, my lord. I 2756.
I think it should go to that bench, is not it?
No, bench is not available. Already retirement. Oh, I'm sorry, my lord.
No, not retired. What you say?
Second petition, sir. Lordship.
Correction in which date?
The bench is available. my lord.
Huh?
Bench is available.
Bench is available. Full stop. Come on. The present application is filed for certain typographical error in order dated 22/12/2021, passed in IA Civil 2221/2021 in WPC
IA civil.
5527.
WPC
5527.
5527/2019. Full stop. Aforesaid order was passed by a coordinate bench and not by this court. Is not it?
Lordship.
Accordingly, matter be listed before the appropriate bench. List accordingly.
Okay.
May it please your lordship. Sir, I'm seeking amendment of the writ petition by way of this interlocutory application.
What was the writ petition for?
In the writ petition, my lord, the petitioner who had LIC policy, which was supposed to mature in 2022. By virtue of that policy, my lord, he was supposed to get some loan as against the policy. In 2019, when he applied for the loan, he got to know that it has fraudulently been placed under lien. And some fraudulent activities were on to bank has connived there, and some loan was given in the name of the petitioner, which subsequently he came to know that his photograph and the signatures were forged in the
No, what is your prayer in the writ petition?
petition. My prayer is that I should get back the whatever amount I was supposed to get under the LIC policy. So the petition was filed in 2019. The policy matured in 2022. So now at this point, I'm also entitled to the entire amount along with it, whatever dividends were there. So my prayer should be amended. And then I had filed one police case also. That has not proceeded. Last occasion, it was before your lordship. And this court has also expressed that unless I array the home department as a party, there cannot be any direction to this. So I'm seeking, I'm also want to make them a party respondent. And the prayer that
Heard. P. Chakraborty, learned counsel for the petitioner, Mr. Sir.
Your lordship, for respondent number 5, Canara Bank.
Respondent number 5,
Did later on in this case, your lordship.
Huh?
We have also implemented later on in this case,
Huh.
your lordship, after filing of the petition.
The present application is filed for seeking amendment and also for implement in the same petition and implement of a new party respondent in view of the subsequent development which has been pleaded at paragraph 5, 6, 7, paragraph 5, 6, and 7. And the proposed amendment the amendment proposed is reflected at paragraph 7
Yes.
as paragraph 13 within brackets small a to paragraph 13 within brackets small d. Full stop. Peruse the pleadings as well as the pleadings in the connected writ petition. In the considered opinion of this court, the subsequent facts as narrated herein above, as narrated in the paragraphs in the IA, shall have a bearing on the determination of this case, and that will not change the nature and character of the writ petition. Accordingly, the prayer for amendment stands allowed, and as IA stands disposed of.
In A, B, C, D. Four paragraphs.
ABCD, full stop. ABCD. Amended petition, writ petition be furnished within a period of
2 weeks, my lord.
within a period of 2 weeks, with an advance copy to the learned counsels for representing party, contesting parties.
Wait, please, your lordship.
Yes, what is this?
My lord, the contempt petition, my lord, the contender number 1 was transferred and in his place, my lord, one Caste, my lord, principal secretary, BTC Kokrajar joined, resumed office, my lord.
Where is the notice to Akashdeep?
My lord, page 9, my lord.
Page 9.
My lordship, all the 3 petitions, my lord.
19. 39. 39 you have submitted.
My lordship.
And what was the period of direction for payment?
It was Tamser Ali, my lord, within
Payment was to be made in terms of Tamser Ali.
my lordship.
Huh?
My lordship.
So your name is not in the list.
It is.
BTC is preparing a list. So Tamser Ali, where is the contempt?
My lordship, it is to examine, my lord, and
And to pay
my lord,
in terms of Tamser Ali.
my lord,
Any specific period?
my lord.
What is the period?
My lord, that is
No period. Any period?
It's on verification, your lordship, with it.
Verification, understand. Verification in terms of Tamser Ali or verification in terms of Tamser Ali within this period. Any period is mentioned.
my lord, that is
No, your lordship.
Tamser Ali, we know that they have prepared a list serially, they will pay.
Yes,
Where is the
yes.
contempt?
all cases, my lord. Yes.
Where is the contempt? Tell us. You have accepted Tamser Ali, what can we do?
My lord, case is that whether it is examination and verification has been done.
So, where is your statement that my case is not verified and my name is not in the list prepared under Tamser Ali?
This, my lord, the respondent will say, my lord.
Where is your statement
I
that
have
my case is
in
not
in
considered verified?
Contempt petition, my lord, it is saying.
In this case,
No, my lord, this is IA, my lord.
no,
For-
IA.
For
Have you
implement of party, my lord.
have you intimated the
I-
new
my lord,
implemented party
my lord.
that still yet not verified? Yes, what is the present status? Is his name is in the list prepared by you?
Your lordship will name then the list, your lordship.
So you want us to see that list? Or you want to see that list whether his name is here standing here in the courtroom?
No, we have the verification, Your Lordship.
Yes, give us the serial number. His serial number.
Is in the serial number, Your Lordships.
In fact, my lord,
7,
the fund is also there, my lord.
That
7.
we understand. Serial number is there.
Yes, Your Lordship, 7, 8, and 9 serial number.
We have passed an order yesterday. Where is that? We'll close this contempt. Call Mr. Nayak. Nayak is there.
Yes,
Call Mr. Nayak. And flag mark his name.
Yes, Your Lord.
And show it to him.
Yes.
Yes. XT.
May please, your lordship.
What is this?
So this is the custodial.
Date of under trial prisoner, my lord.
So I was supposed to file.
Inquiry report is
it,
here.
but my lord, I could not file because my lord, the petitioner, my lord, he's probably ailing, my lord, 77 years old. My lord, within Friday, my lord, I can file. My lord.
On the prayer of the learned council, this is 2013 matter. Nothing there, nothing is there.
One thing I would like to point out, my lord, if he is have some allegation regarding that inquiry, my lord, it has to be independently challenged.
You
my lord.
understand, even if we allow,
Otherwise,
what
I
will
could not
he
have
do?
filed
Why he's want to drag this matter, we do not know. In a given case, we'll go beyond everything. But this is not that case.
My lord, there are, my lord, certain, my lord, thing I have to, my lord, point out.
We are
during
only
my
giving time
Yes,
because it relates to a date of a person.
My lord.
That's why we are granting you time. Indulgence we are giving.
If he has any.
But there is a limit to stressing the elasticity.
My lord,
And
by-
it should not be stretched to that point where it is broken. In every field in your life, the elasticity should be to its limit, not beyond a point where it gets broken. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed in the first week of November 2025.
Obliged.
Yes, Mr. Nath, we have passed, if his name is there, money is there, you consider his case, that's all.
Only condition that once is the person
That's it.
above him is
See,
paid, he will be paid.
Tomserali is that only. And that's why I have specifically asked, what is the order? Order is not giving any specific period, only Tomserali. And in terms of Tomserali, you will have to go under seriatim. We cannot see.
Some cases, honorable court, you would prefer to use the word forthwith
That is
and then pay forthwith. So that is the difficulty we are facing. Lord.
that is according to this court, when Tomserali is applicable, then we cannot give a period. Understand? Because Tomserali itself says that it should be given on the basis of seriatim of claim.
That is.
If you have gone through the Tomserali.
Yes, Lord. That
So
is the-
if that be so, how can we sit over the judgment of a three judges bench? Tomserali is a three judges bench.
Three judges, full
Three
judge.
judges bench and say that pay forthwith.
Lord. That
This
the-
is one aspect. So far relating to the state of Assam, where this FBRM or Act is applicable. Here payment is earmarked against nowadays after that Act
Now, Lord.
is
now.
against each payment. So Tomserali's seriatim decision we can say is not applicable in the given case in FRBM.
These are basically cases, Lordship, which were allotted prior to
That-
the AFRBM Act. Lord.
FBRM.
Prior to 2005.
And BTC, I think, do not think they have made applicable
Yes,
that Act. They have not opted. So this is the, I think this is the case. So we cannot pass an order.
Close this matter.
We'll close
Only
it.
that
I
line. Lord,
passed an order, you were there on day before yesterday.
Only that observation.
That
Lord.
observation, that he will be
that
paid
they
in
will be
its
paid in
seriatim.
Yes, Lord.
Only my lord, the time frame, my lord.
Time frame we cannot give. See, if we give time frame, that will be in violation of Tomserali. Tomserali says it should be paid in seriatim, seniority of claim. Specific word is used. I think so far I remember. Seniority of claim. And you have agreed that yes, it should be paid. And it is not your case that money was sanctioned against my project.
Claim is at serial number 789. Once the person at serial number 6 is paid.
789 your claim. Where is that order? You remember? We'll close this for in view of the order pass IS stands close.
I'm praying for that observation.
That
I
observation.
have annexed, my lord, in my petition, the fund is also there with the.
Oh, understand.
Yes, my lord.
Fund is not meant for you.
Yes, yes, yes. My
So
lord.
if it is an FRBM, then fund is meant for you only. We cannot ask that from this fund, give the amount to at which serial number at serial number 5. That we cannot pass. If it is in your name, even if you are at serial number 7. But in terms of Tomserali, you will be entitled only he's in 7.
Yes.
6 amount is cleared.
6 amount.
Understand?
If somebody below him, lordship, has been paid lordship, then he will have a case, lordship.
He will have a case not for his claim to against that, and that will create a difficulty. We expect that you are maintaining the seriatim.
We are maintaining lordship.
That is all. That is what you dispose of both IA and contempt.
Close lordship.
Yes, close.
3 cases.
Okay.
All cases, na? All 56 to
3 cases.
3 cases.
3 cases.
With IA. IA is for implement. In view of order passed till main, IA stands closed.
Deeply over.
Order is over.
Last occasion, we also take instruction whether the security money can be refunded to the petitioner. As per rule, we cannot refund it, your lordship, because she has defaulted in payment of the Caste. However, she has an alternate remedy to approach the PCCF, lordship, by filing an appeal. That she has not done, because termination order was issued by the DFO, lordship. Termination of contract order. And the forfeiture security money is done as per the agreement which the department and the petitioner have signed, your lordship, which they have not annexed, but is a model form in the book, which says the forfeiture can be taken place in case of default.
What is the period of appeal? Yes, what you say, madam?
Let them file their exhibit, my lord.
They can
That will delay your process. If that is
Just sort that, my lord.
no, we are adjourned. There is no problem on your adjournment.
Already it is late, my lord.
No, therefore we are saying we can, if that is the provision. See, we are also thinking on the. That's why I have asked specific instruction. Here may have some claim, whether they are correct. You are also having a claim, 2 claims that there was no material. Number 1. Number 2, you have given mining permit within my mining contract. Third is that I could not extract, so it was terminated. This is your case.
Yes.
Their case might be you have terminated for your fault, you have defaulted, and therefore your money is forfeited. Can we determine these factual aspects in this writ petition, more particularly when a specific appeal is provided against the order of DFO? Okay, if you want to, if I'll sort affidavit.
Very well, lordship.
Sort that maybe.
Pursuant to this court's order dated 10/9/2024. As regards release of security deposit of money amounting to rupees 33,46,333. Mr. Gogoi, Learned Standing Counsel for the Forest Department, on instruction submits that such amount has been forfeited in terms of the mining contract
Agreement, your lord.
Huh?
Agreement. They made
Mining agreement entered into between the petitioner and the forest department. It is his further contention that there is a provision of appeal under
Rule 68, your lordship.
Rule 68 of
Assam Minor Mineral Concession Rule
Assam
2013.
Minor Mineral Concession Rules
2013.
2013. And therefore, this court may not exercise its jurisdiction to determine the factual aspect whether the claim of the petitioner is correct or the department is correct in its action. Let the department file an affidavit bringing on their contentions as raised herein above, and also the contract entered into between the parties. Please this matter after vacation. 3 matters.
Obliged, lord.
Order is passed in 4130.
Obliged.
May it please your lordship?
Hmm.
Item number 910. Respondent number 7.
What is your name?
Krishna Pathak.
Respondent number 7. Yes. K. Pathak, correspondent. Yes. Next, 11.
May I please, your lordship? In this matter, lordship, during the pendency of the proceeding, lordship, petitioner number 1, 3, and 4 already expired, lordship. And their legal heir may be substituted, lordship, finally.
What is the issue here?
Issue is that the railway has illegally occupied our land.
Still occupying?
Still
Let them occupy. You file a impediment.
I've already filed my affidavit.
Yes, I've seen it. Learned counsel for the petitioner submits that the legal heirs are that the respondent number
Petitioner number 1, 3, and 4.
1, 3, 4 and in the meantime expired, and their legal heirs want to implicate themselves in the present writ petition as cause of action survives. Accordingly, she is pressed for an adjournment. Prayer stands allowed. Please this matter in the second week of November 2024.
In the meantime, my lord, the state's affidavit would be necessary in this case. My lord.
Full stop. As the dispute pertains to claim and counterclaim over the land by the railway as well as the petitioner, in the considered opinion of this court, affidavit from the revenue authority, more particularly respondent number
Land revenue minor 6. 5 and 6.
respondent number 5 is 6 shall be necessary.
4, 5, 6.
4, 5, 6 shall be necessary. Accordingly, in the meantime,
Because of this filing of this affidavit, I am just pressing one thing at page number 41, lordship.
is 41.
This is a letter issued by the railway authority to the petitioner. In second paragraph, they have stated, moreover, as your lordship got it. It is particularly mentioned here, any scheduled land is under the position of railway for last 40-50 years.
Oh, this wrong, yeah.
This
There is nothing in your case. This
Lordship.
wrong, yeah, case.
If the lordship see the last page of my affidavit,
No, I've
my
seen
lord,
that.
the admission is there that it was acquired, my lord.
Lordship,
A day one
this
compensation.
is
my lord.
another matter, lordship. Earlier also one matter I have seen, lordship.
No, that is different. That is different. That is land acquired, record corrected, everything.
It's not acquired, lordship.
Which
And
case?
we are
Which
paying
case?
revenue,
My
lordship.
affidavit, my lord. Their admission, my lord. They write
Nothing
to the
survives.
PMO office, my lord, asking for compensation. They themselves admitted that this is land was acquired, my lord, but they have not received the compensation. They also admitted that it is under the possession of the railways, my lord. This was forwarded to us
Any
from the
stay
PMO
order?
office.
Any stay order?
No.
Continue. Oh, nothing in this case. It's, your petitioner is saved by his death.
But I am
No, not necessary.
Lordship, in this matter, M.K. Sharma, one counsel is appearing in this matter.
No, we
lordship.
do not know. Whoever appears, he appears. If the state affidavit is not necessary.
Lordship, already railway has filed affidavit.
Railway has
Lordship,
filed
in this
affidavit,
matter.
that's all. To file an appropriate application. Leave this matter in the second week of November. Much obliged.
We need not to file affidavit, Lordship.
No, you have,
Lordship.
if necessary, we'll have instruction, what
Lordship.
status of the land, that's all.
Last 2, 3 occasions, Lordship.
None appears for the petitioner on call. Matter stands dismissed for non-prosecution. Interim order pass earlier stands vacated, and the respondent authorities shall be at liberty to proceed with the enquiry. And enquiry if so advised.
Obliged, Lordship.
None appears for the petitioner on call. None did represent the petitioner on 17/11/2022. Until 17/11/2020. Mr. K. Gogoi, Learned Standing Council, is present and submits that this matter in fact has become infructuous. Be that as it may, as none appears for the petitioner on call, his petition stands dismissed for non-prosecution. Which is the department? Huh? I have gotten the amount. None appears for the petition. 2015. None appears for the petitioner on call. None did represent the petitioner when the matter was called on 6/11/2020. Mr. Gogoi, same order is present. Not infructuous is not right now. Gogoi is present. This matter stands dismissed for non-prosecution.
See, instead of standing council, my lord, make government council.
Huh?
Instead of government council.
State standing council, that's why it comes as. Yes. Item
1-5.
roadside land.
Lordship.
Have you filed
Most
affidavit?
probably evicted, that is.
Have you filed?
No,
No
not yet.
affidavit. What is the present status?
That is also, I have no knowledge.
None appears for the petitioner on call.
You can get that.
None appears for petitioner on call. An order. The petitioner has challenged a notice dated 18/4/2017 under section 18 and under rule 18 of the settlement rules framed under as Assam Land and Revenue Regulation 1886. 1886. Said order has been stayed by this court under this order dated 8/5/2017. Eighteen for 2017, no notice. In as much as it is the stand of the state as reflected from different orders that the shop which is sought to be demolished is constructed over a roadside reserve land under Dag number 73 of Lekhapani Gaon under Tirap Moja. However, no specific affidavit has been filed till date. It's an eviction, we cannot dismiss like that. And there is an interim order operating. In the aforesaid backdrop, Mr. Sharma, Learned Counsel, submits that he will complete his instruction and file a necessary file affidavit if so advised.
We have received the instructions in 2018, but recent instruction we will get and thereafter Lordship will file.
File an affidavit. Prayer stands allowed. list this matter in the second week of November 2020.
May I pray for a date, Lord? If it is not,
Give a date. Second week of November. 13th of
Lord.
Lordship, I beg to mention item number 12, Lordship, I was in legs because
We
of
do
which I
not know
was-
that.
it
This
was
is not,
dispersed
this
due
is
to
not the
non-
time to mention.
Yes, my
No,
lord.
no, not at all.
It was
Please, next
dispersed.
case. Next case.
This replication has been.
Where are you going for disposal? Any extensive hearing is required?
It, some
Huh?
time will be required.
Then not before vacation.
The lordship kindly fix a date.
We'll fix a date.
Lord,
Give a date as per your convenience on on the hearing date.
after the vacation,
Give a date.
okay, no?
Matters which requires a CAV
Yes.
is not before vacation.
That is, my lord, a little unfair to the court also.
Yes. Just we are clearing the things. Hopefully by next week we'll be out without any CAV.
29th of October is a Tuesday.
That will be done or this one.
As agreed to by the learned counsel for the parties, this matter is fixed on 29th of October 2024 for admission hearing.
The final, my lord,
Finally, an endeavor shall be made for a final disposal of the matter as this matter is pending since 2017.
final.
Just tell us, by any chance, did I appear any cases for APDCL as a lawyer in case of Sivo alloy steels?
Lordship, may I have it after 5 minutes? I just check.
Huh?
I did not check that.
I have seen in this case that there is nothing, but these names came to my mind. I think there was an earlier litigation.
Repeat offender, Lordship.
Repeated offender. So, so far I recall, these names comes to my name. There may be a reported judgment also, Sivo alloys.
Yes, my lord. That is with me, my lord.
Huh?
Probably, my lord. Probably more with me, my lord. No, not today. No, my lord, not today.
Let us not take up this matter today. I am also a little bit confused.
I thought, my lord, lordship will dispose of this case today.
No, we can dispose it of, but the difficulty is that because I have seen somewhere NJ Datta's name.
Yes. Yes. Sir.
So we, at that point of time, we together appeared in these cases. I think this matter clicks in my mind, Sivo alloys. This name comes to my mind.
Very good.
Earlier, there was a litigation. It was remanded back.
Yes.
That question of the theft and these both were involved.
Yes.
Theft, and I think I recall all these things.
Very well.
On the prayer of the learned, just verify it. On the prayer of the learned counsel for the parties, list this matter. When? When?
After vacation, then
Not before vacation. Give a date.
My lord, after 20, any date, my lord, after 20th.
After 28, give any date.
Any date, my lord.
Okay. After 20, anything.
This November.
25th.
25th, I have some difficulty.
Okay, give us a date.
28. 28. Deeply agreed.
Deeply.
Lordship, in the matter, we have received an affidavit in opposition on 19th/9/24. We'd like some time to file our affidavit.
You are?
Petitioner.
Your name, please?
P. Agarwal.
P. Agarwal, learned counsel for the MSP Agarwal, learned counsel for the petitioner submits that They have received an affidavit in opposition filed by the PDCL on 19th of September 2024. Accordingly, they may be granted some time to go through the same and to respond if so advised. Prayer is allowed. List this matter.
They have to
Same
file-
date,
Very well.
29, 28, 28 of October.
Publish.
This matter, my lord,
Ah.
today I file an affidavit in reply, my lord.
Ah.
So, my lord, let it be taken after vacation.
Okay.
In the month of November.
It is submitted by Mr. NNB Chaudhuri, learned counsel for the petitioner, that a reply affidavit has been filed today. Yes, today. Same is not on record. Accordingly, let this matter be listed.
After after November 6, any date, my lord.
6 any date. After 10th any date. Give a date. After 10th of November. 11th of November 2020. Plus. Same policy, issue same.
No, my lord.
This is different. Yes.
It's a very short issue, you don't, if you lost it.
Yes, you want to.
Similar case was there, Lordship.
Considered appropriate in the next meeting.
No, no, I have lost my seat. That is,
If you go through it.
I've gone through it, that is for COVID-19, my lord.
Ah.
But here your lawsuit is fine. Just lawsuit motion to this. But the policy at page 31.
Where is Mr. Kalita?
Actually, he's not present today, Lordship.
Page 31 and paragraph, page 32, you'll also see.
Page 32.
Substantial expansion, you know. At the top.
Okay.
Incentives on substantial expansion will be given to units affecting an increase by not less than 25% in the value of fixed capital investment in plant and machinery for the purpose of expansion of the capacity modernization diversification as against the increase of 33.1% in 1997. In 1997, it was 33.1%, but now it is said by 25%. Now, what is
Mr.
required?
Saraf, it will be a difficulty on his part. He was with an impression that it will be disposed of in view of this order. So since you are saying it is something different, let Mr.
If by this order it is set aside and to consider that, my lord, my job is also over, but my lord, the issue is here different. My lord.
Okay, therefore, in absence, it will not go to the, since you are saying not similar, it will be not be fair with, I think so.
After vacation.
After vacation. You are Mr.
N. Kalita.
N. Kalita, learned counsel appearing on behalf of Mr. A. Kalita, submits that this case is covered by the determination made in WPC 5497/2022. However, Dr. Saraf, learned senior counsel, submits that the issues are different, or therefore of adjudication is required in this writ petition. Today, Mr. A. Kalita is not present. Therefore, this matter stands adjourned for adjudication on
Vacation.
after vacation. Give it.
If you lost it, date, otherwise it will.
We'll give a date. That's right. First week of November. October will be like that only. First week of November. Yes, Mosu. 4th of November.
I've given the notes which you also desired, my lord.
Yes. That matter we have fixed when?
Tomorrow.
Tomorrow.
Obliged.
What to be done?
Well, sometime maybe in the lordship. We're waiting for the instruction from our client lordship.
That has been constructed already.
Lordship, up-to-date instruction is not with us.
Because you are permitted to construct, but not to transfer the title. Have you constructed?
Lordship, up-to-date instruction, I required up-to-date
Okay.
instruction.
The present writ petition was filed being aggrieved by the petitioner, being aggrieved by a letter dated 15/7/2018 of the executive member of Karbi Anglang Autonomous Council, within bracket KAAC, informing the petitioner number 2 that CCI playground at Bokazan is suitable for construction of one mini stadium with an open stage, and for that the government of Assam has sanctioned 10 crores of the project. It is the case of the petitioner that it is a private property of the CCI. Therefore, no construction should be made. This court, while issuing notice of motion, while permitting the authorities, while permitting Karbi Anglang Autonomous Council to develop and improve the playground, but ownership of the petitioner over the said plot was directed to be maintained. Full stop. The petitioner, as well as the learned counsel representing KASC, are not updated with the instruction whether the construction has already made or not. Accordingly, they have prayed for an adjournment. Prayer stands allowed. List this matter. After vacation, give a date. This is the issue. Then there will be issue if you have not constructed, matter ends, infructuous. And if you have constructed, what should be the ownership? Who should be the owner? That's all. Then we'll relegate you to both of you there. If you either acquire this land or have an understanding that they will also use, you will also use. We do not know. Just have the instruction. 25th of October.
May I please your lordship? Matter is regarding compensation, value of land and the
Power grid.
power grid.
Yes.
A batch of the petition discussed by this honorable court.
Similar. Out of the same area.
Same.
Give us.
Similar direction.
Now tell us which is the area. You are Mr.
I am on behalf of S.A. Ahmed.
Okay, S.A. Ahmed. And K. Fukan for AGCL.
Yes, your lordship.
And who for respondent number 3 and 4? Or you are for 3 and 4?
Yes, your lordship.
Okay.
3 and 4.
Who is the district judge here? In your case, which district?
Hello.
District.
District Baksa with
Same. But district judge Baksa.
Same.
Dispose of. Same on this. Names, everything is simple. Paste it. No? Okay. Device is good. Copy and paste. Dispose of.
Obliging.
I am placing
This was
this
item
matter
number?
for disposal, my lord. My lord, I am placing this matter for disposal, my lord. I am placing this matter for disposal, my lord. My lord, more than 1 year, 3 months back.
Okay.
Lordship may kindly come.
Lordship may kindly come to page number 17.
7?
The order impugned 17, my lord.
17 of your affidavit.
Petitioner,
Okay.
petition. Affidavit not filed. This is the impugn order, my lord, by which, my lord, the secretary of the Dimoguri Gaon Panchayat has cancelled the NOC which was earlier granted on a complaint of, my lord,
Who are
the
you?
private respondents.
Let me sub.
Lordship.
Okay.
Actually, we have not filed our affidavit, Lordship. The
Let there be demarcation.
That is where I was supposed to answer, my lord.
Let there be demarcation. If there is a dispute so far relatively who has encroached whom,
My lord.
there shall not be no.
Land belongs to me. Lordship may kindly come to the.
Mr.
annexation.
Bakshi, do you want this court to declare that land belongs to you
No, my lord, what has happened
without
giving
demarcation?
without giving any reasonable opportunity, my lord. This, my lord, annexation page 17, my lord, that has been issued, my lord.
There is no reasonable opportunities required. It says we'll demarcate. Thereafter, this NOC has not been cancelled or withdrawn. It is suspended
Temporarily.
temporarily. So we are sending you to the authorities. They will demarcate it.
Temporarily cancel, my lord.
Yes.
Okay, we'll treat it to be an NOC subject to demarcation. Let it people go to demarcation. But suppose it demarcation, it comes out that you are encroaching their land
Yes.
or they are encroaching your land. Municipal authority can do nothing.
Panchayat authority.
As simple, Panchayat or they as simple and that. Then both of will have to go to the civil court.
Yes.
We cannot authorize these circle officers, panchayats to demarcate and demolish. As simple as that.
That is what he is saying, that unless it is settled by the circle officer.
Huh?
And this, my lord, impugned order, my lord.
Huh?
That says, my lord.
No. Therefore, what I am saying
That
is,
demarcation cancel.
suppose as per demarcation, there is no dispute.
Yes, my lord.
There is no dispute. It is you want to construct a boundary wall in your property.
Yes.
They will issue the NOC.
Yes.
But if there is any dispute, then they cannot decide. They will relegate to the civil court.
Let appropriate order be
That
filed.
is the order of approach. Heard Mr. Bakshi, learned counsel for the petitioners. Also, Mr. Datta for
Respondent number 5.
respondent number 5. Ms. Nirala,
Respondent number 4, Lordship,
respondent number 4.
on behalf of A.K. Gupta. My name is not.
Okay. Is he here in Guwahati? In the courts?
He's on legs.
Okay. A.K. Gupta, learned the counsel for respondent number
4, Lordship.
4. And you are for item number 3. R1.
Who is the circle officer by name, my lord?
Forget about it.
Oh.
The case of the petitioner in brief is that petitioner intended to construct a boundary wall over his private patta land covered by DAG number 528, PP number 77, and accordingly he applied for a no objection certificate for construction before the respondent number
5.
5. Full stop. The respondent number 5 thereafter by NOC dated 8/12/2020 granted the permission to construct. While the petitioner started construction, the impugned communication was served upon the petition. Impugned communication dated 3/2/2021 was served upon the petitioner, cancelling the NOC, earlier NOC dated 8/12/2020. Being aggrieved, the present application is filed. It is the case of the respondent number, private respondent, Nirala.
Respondent number 4, Lordship.
Respondent number 4, that the petitioner has encroached their land and tried to construct the boundary wall. Therefore, they have raised objection to such NOC. Full stop. Mr. Datta, learned counsel, submits that a reading of the NOC, a reading of the impugned order dated 3/2/2021 clearly discloses the intention of the authority that they want to first demarcate the land and want to temporarily suspend such NOC on the basis of the complaint filed by the respondent number 4. Therefore, no right, according to Mr. Datta, no right of the petitioner has been violated, and in the event after demarcation, it is found that petitioner's proposed construction is over his patta land, no NOC shall be freshly issued. In the aforesaid, in view of the dispute, this court is also of the opinion that matters should be relegated to the authorities to first determine, first demarcate the land in question between the petitioner and respondent number 4. And in the event it is found that the proposed construction is over the patta land of the petitioner, shall be allowed as per extant norms. Full stop. In the event it is found by the authorities that there is disputes as regards the area, as regards the land over which proposed construction is given, and there is claims and counterclaims, the parties should be relegated to the civil court for determination of their right. Full stop. We therefore said, full stop. The demarcation be made in presence of both the petitioner and respondent number 4. Full stop. The petitioner and respondent number 4 is directed to appear before whom? Circle officer. Circle officer, which revenue circle?
Lord, Tinsukia Revenue Circle.
Tinsukia Revenue Circle on 21st of October, after Puja. 21st of October 2024, on which date the circle officer may fix a date intimating both the parties to remain present and to do the demarcation. Full stop. Such demarcation be made within 3 weeks from the date of appearance of the parties before the circle officer. It therefore said disposes the repetition.
Obliged.
Yes, but what is this?
Here, similar on the similar issue, lots of other writ petitions were there, which were hard, and now it's CAV.
Okay. It is submitted that issues involving in the present writ petition
Lots of before Honorable Justice S. Right there.
has been heard by a coordinate bench within bracket as and judgment has been reserved. In view of the aforesaid, the present matter stands adjourned and be listed after 6 weeks.
No, sir, I'm sorry.
What is the present status? He was a sub-agent of your sub-agent. You are directly engaged by bank.
Lords.
Then you have engaged him.
Lords.
His thing has been cancelled by SBI.
Lords. Not by SBI. SBI wrote to us.
You have done it.
No, our case was this.
None appears for the petitioner on call, though Mr. S. Borthakur, learned counsel, is present representing respondent number, and Mr.
For respondent 1, 2, and 3.
Respondent number 1, 2, and 3. In view of the aforesaid, writ petition stands dismissed for non-prosecution. Interim order, if any, stands vacated. Why should we in simple case? That's why he's not coming. Yes.
May I please, Your Lordships?
Yes.
My lord, earlier counsels no longer in this case. We are newly appointed counsels.
Okay.
My lord, at first, my lord, regarding the additional affidavit, my lord, we are not pressing that affidavit, my lord. Instead, we have going to file a reply to the affidavit in opposition, my lord.
You want some time?
I want some time, my lord.
The learned counsel for
We are not pressing the additional affidavit.
we are not saying anything now.
11, 12.
The learned counsel for the petitioner submits that he has newly been engaged in district petition and would like to bring some additional affidavit.
My lord, reply.
Would like to file a reply affidavit.
Reply against the affidavit in opposition filed by respondent
Reply
number 2.
affidavit to the affidavit in opposition filed by
Respondent number 2.
respondent number 2. Prayer is allowed. List this matter after vacation.
And my lord, there is an incomplete annexure, my lord. Page 5, my lord, of the affidavit in opposition.
When you are filing a reply, write a paragraph that this was incomplete. Which their affidavit was incomplete.
But that is required for us, my lord.
Yes, which one is this?
Reverse side of the affidavit, my lord. Reverse side of the affidavit, my lord. Page 5, serial page 80.
80.
Then it will be 81. ইয়াত লেখা আছে হিপিটিত নিম্ন চৰ্তত ভোগ দখল কৰিবলৈ আবণ্টন দিয়া হ'ল। There were some conditions, my lord, in reverse side with the affidavit.
Are you having these conditions with you?
No, no, my lord, not with me.
Okay, we'll decide if it is necessary on that day. We are not passing any order today. Think over it.
There is a interim order, my lord.
Interim order pass earlier shall continue till the next of date of listing. Give a date of listing. This is reverse erosion, affected people. Or what?
My lord, settlement of land, my lord.
Settlement
in
of land.
Government land, my lord.
That's why government proposed to settle in your favor. Why? You must be some, you
My
have
lord, giving some other part of land, my lord,
Okay.
not that land.
in lieu of
In which possession we have still.
811.
Of placement.
Matter may become infectious.
Infectious. Learned counsel for the petitioner submits that in view of confiscation of the vehicle in question, the present writ petition has become infructuous and same may be closed with a liberty to the petitioner to take legal remedy in terms of provision of section 115 of the Customs Act 1962. No, 128 of the Customs Act 1962. And according to the, inasmuch as according to the respondent, the confiscation was executed in terms of section 115 of the Customs Act 1962. This is your case?
Yes.
That is okay. Accordingly, this petition stands closed with the liberty as prayed for.
I do.
In this matter, we'll file affidavit to the lordship.
You are for?
I'm for Water Resource Department, lordship. Water Resource Department.
Learned Standing Council for Water Resource Department prays for and is granted 2 weeks time to file an affidavit. Yes.
They have filed, lordship. I'll file this.
We'll file it today, lordship.
We are filing today.
Yes.
Is Learned Standing Council for the Water Resource Department submits that an affidavit has been filed today. Same is not on record. List this matter after vacation. First up, in the meantime, the registry shall verify and place the said affidavit on record. First up, the petitioner may file reply if so advised.
Can I pray for a date?
November, I can give you a date.
Okay.
The given date, November. 18th of November.
Matter leads to cancellation of caste certificate of the petitioner. So they have already filed their affidavit in opposition.
What is their stand?
Their stand is that no hearing has been taken place prior to cancellation.
Now, who passed this order?
The deputy commissioner, lordship.
No.
How is deputy commissioner authorized under Madhuri Patil?
No, as per Madhuri Patil, minor may dispose of.
The state level caste scrutiny committee, the state level caste scrutiny committee can only decide when there is a dispute. R. Bora.
Mr. R. Bora, learned counsel for the petitioner. Mr.
G.
Bokolial for
respondent.
government of respondent number 1 to 4. 1. A. Pukan for respondent number 1. Bokolial for
1 to 5.
No,
Or 2 to 5. 2 to 5.
2 to 5.
1, 2, and 3.
C. Sharma for 5. Then Bokolial, you clarify.
2 and 3 and 4.
2, 3, and 4. Then Sharma for
5, lordship.
5. Aggrieved by an order dated 2/9/2023, by means of which, the caste certificate of the petitioner was cancelled, the present writ petition is filed. Full stop. The contention of the writ petitioner is that The impugn order dated 2/3/2023 has been passed in most arbitrary and illegal manner and in violation of the law laid down by the Honorable Apex Court in the case of Kumari Madhuri Patil versus State of Maharashtra and others, reported in 1994 6 SCC 241. Full stop. The impugn order. Where is that impugn order?
Page 18, Lordship.
Page 18.
Yes, Lordship.
The caste certificate was issued to the petitioner on 2/9/2023 by the who issued you?
Lordship, the Office of the Deputy Commissioner.
By the competent authority under the Deputy Commissioner, West Karbi Anglang District,
Yes, Lordship.
certifying that
Page 17 is the caste certificate issued by the.
certifying that the petitioner is Koiri, Koiri, within bracket, tree garden laborers / tea garden tribes / ex-tree garden tribe. Ex-tree garden, Arden, ARDEN, Arden tribes. Which is recognized as other backward classes / more other backward class by Government of Assam. Such certificate issued was cancelled by the Assistant Commissioner, West Karbi Anglang District, by the impugn order dated 3/10/2023 on the ground that the petitioner's certification was issued in absence of the recommendation from Shah Janojati Jatiyo Sanmilani, West Karbi Anglong, in terms of the Department of Social Justice Empowerment's letter number ECF 228962/23 dated May 2023. According to the cancellation order, the petitioner has not submitted any recommendation from Shah Janajati Jatiya Sanmilani, West Karbi Anglong, nor any relevant documents for his father or forefather engaged in ex-tree garden laborers were furnished. And he has also not submitted the physical caste certificate under subcaste query earlier issued. Full stop. The respondent state has filed an affidavit taking the similar stand. However, it is admitted that the petitioner was not given any opportunity of hearing before passing of the impugn order. Full stop. Madhuri Patil will not be applicable here. They have not disputed your caste as such. They are not saying that you do not belong to Koiri. They are only saying there is a procedural lapses. So let them consider it. It is not that they are not saying you are not query. What they are saying is, so there is no determination as on date required from the Madhuri Patil's committee.
But the lordship, the moment they cancel my caste certificate, this caste certificate, because in 1995, the same respondent had issued a caste certificate in my favor saying that your lordship will find at page 16.
Therefore,
That
page
is in 1995, which says that I belong to that
Page,
particular
page,
page
page.
16, 16.
16.
12/9/1995.
Okay.
That
Oh, 16. Okay. Full stop. Come on. The fact also remains. It has not been disputed, na?
Not disputed.
Okay. Fact also remains. In fact, in the order it says, fact also remains that a caste certificate of OBC/MOBC was issued by the then subdivisional officer within bracket C, Hamren subdivision Hamren, certifying that the petitioner belongs to
Koiri extra tea garden tribe.
Koiri X Tree Garden tribe.
Extra tea garden tribe. Clearly turned out.
That is X Tree Garden tribe. Full stop. Therefore, apparently from the impugn order, it is seen that for 3 reasons the certificate issues was cancelled. Firstly, that the such certificate did not contain a certification from
জনজাতি জাতীয় সম্মিলনী
জনজাতি জাতীয় সম্মিলনী
ওয়েস্ট কার্বি আংলং
West Karbi Anglam in terms of notification dated
May 2023.
in terms of the notification dated
Page 18, your lordship will find page 18, paragraph number 3. Page 18, 18.
18.
The impugn order.
No, 18 is the impugn order.
Yes.
No, on 29th of March 2022, and that the petitioner had not submitted the earlier certificate issued in his favor.
Lordship, that is where the contradiction is. Lordship may kindly see the impugn order at the first paragraph, whereas it is seen that Sri so-and-so has been issued caste certificate by so-and-so, under the applicant has submitted the following documents. Now, at first they say that physical caste certificate of Gajendra Singh dated 12/9/1995 that I have submitted. On the bottom of the page, they say that I had not submitted that caste certificate.
However, if the impugn order is seen, it is clearly disclosed that the petitioner has submitted along with his application the caste certificate earlier issued on 12/9/1995. Therefore, this part of the impugn order is not based on the material placed before it in it. Therefore, it is nothing but a perverse decision. So far, coming to the application, though it has not been submitted, however, without hearing the petitioner, the authorities could not have cancelled the certificate issued in favor of the petitioner, more particularly when the petitioner was having a caste certificate issued on 12/9/1995, until and unless such caste certificate issued in earlier point of time is held to be fraudulent or non-existent, such ground could not have been the reason for setting aside the order. Be that as it may, as the petitioner did not have any opportunity to place his stand before cancellation of certificate in the considered opinion of this court, the impugn order is liable to be interfered for non-adherence of principles of natural justice. Accordingly, in the totality of the matter, the impugn order dated 3/10/2023 passed by Assistant Commissioner West Karbi Anglam District Hamren stands aside. Full stop. However, it is provided that if the respondent authority still wants a verification or wants a verification or any doubt as regards the certificate issued to the petitioner, they may, the certificate issued already to the petitioner, comma, they may issue a notice to the petitioner to place his defense, and thereafter they may pass an appropriate order if so advised. With the aforesaid, the writ petition stands allowed. Anything survives?
No, because what has happened is we have challenged the order. No, because there is a stay order in our favor. What has happened initially, the order of the Ancillary Concert was challenged, it was stayed. We were supporting the order of the government. The government has said that we should continue. Now, what has happened? Actually, there are two sets of writ petitions filed. We are supporting the government stand and the one who were cancelled. And they have also filed writ petitions. All these were fixed on 30th of this month. I can give your lordship can hear all the matters together on 38th itself, your lordship. That can be done. Because what has happened, because if this is heard and some decision is taken here, the others will also be affected. Somewhere or the other.
No, now tell us, your period is otherwise over.
No, otherwise over, but what has happened? I'm just pointing out page 33. This is the orders by the governor, notification by the governor.
Governor said that you continue.
Yes, we continue for the period.
Period.
Extension, because that will continue beyond the period. Because until and unless the new persons are selected.
Okay.
All those which were selected has been set aside by the government. So they have filed a writ petition that is there.
Understand.
That is fine. Now we said that yes, since we are allowed to continue.
But
we
the
continue.
period for which this litigation was there, that is also over.
No, that period is not over, your lordship.
Yes, tell us, what is the date?
This date, your lordship.
What was your first settlement here? Tell us.
No, that period is over.
No, just tell us.
Yes. This is the big first settlement was
for the period
from 21/7/23 to 36/24.
First settlement period was? It should be for 1 year.
Yes, 1 year, 1 year.
Tell us.
21/7 to
21/7 to
36.
36 of
24.
Not 24.
24.
24.
36 of 24.
Yes.
Okay.
So that period is over.
So
we continue on the basis of the government.
Now, when the government's order was issued?
Government order, your lordship will file 29/6/2020.
Therefore, we are
That's before that.
Therefore, we are asking you, what was the initial period?
Initial period was 1 day after the government.
So you are, by virtue of initially you had a period through tender process. Subsequently, there were supposed to be tender,
yes,
but that was extended. Okay, that extension is under challenge.
That extension is under challenge by a batch of.
Understand? That extension is under challenge. The extension was for till 36 to 24.
No, not 36. Extension is not 36.
Extension is when?
Extension is for beyond
36,
my lord.
Beyond 36. That is why I'm saying.
Extension is beyond 36, 24 till?
No till. No till is there. That is the government.
Now, government has not withdrawn that.
That was stayed, my lord. That
We are
notification
supporting
stayed.
the government part.
So that has been stayed.
Yes.
Now,
my lord,
after that, what did you do?
lordship, kindly see the page 33 once again, my lord.
Page
33.
33
This
is
was
the
the
order.
29/6 notification by which, my lord, all the new tenders has been cancelled, and up to the new settlement, my lord, the ex-lessee was supposed to extend, my lord.
That
But
was
this-
stayed.
Yes, this notification was stayed, my lord.
No, that was stayed. This was also stayed. The order which says actually in our favor was against us, that was also stayed in this writ.
My lord,
So
before
there were both stay orders passed by the same court. That
may-
is
may
why
I
when the
clarify-
matter went before the court said that this matter should be list along with that.
may I clarify, my lord? Before my lord challenging this notification, this petitioner filed this writ petition, my
Yes.
lord. And honorable court directed, my lord, that as the notification is still there.
How
at
many
that time-
matters are there?
I think I have a list of 3-4 matters.
Do you have a list?
I can.
I have the.
When
I
are
have
you
the-
proposing to have the tender?
This matter was fixed on 36, my lord.
All these
On
matters on 36.
When are you
Yes.
proposing to go
As
for
the
tender?
decision was taken from the cabinet, my lord.
When?
We have prepared, my lord.
Ah.
Prepared and draft was submitted to the cabinet, my lord.
For
Now-
advertisement?
No, my lord, for model NIT, my lord. The approval of the
Okay, model NIT.
Yes. After the approval of the subcommittee of the cabinet, my lord, we will circulate the model NIT to the Anchalik Panchayat. Thereafter only NIT will be issued, my lord.
Okay, what is the present status of that?
The cabinet only, my lord. We have
So
already-
you also want to enjoy them without tender?
My lord, that is why, my lord, the matters has been fixed on 30th, 39, 2030, my lord.
This 30.
And lordship has already verbally told us, my lord, if till 30 we will not finalize the modern NIT, then court will pass, my lord, appropriate order. My lord.
Okay, which is the matter order pass? I will also do it.
Number is, your lordship, WPC 3663.
It is submitted that similar order is fixed for, yes,
I'm for the private restaurant.
that we know. Anything more than that?
I have filed a stay vacate, my lord. I have filed a stay
So you
vacate
want
from-
the stay vacating to be today or 38?
They vacating because nothing, my lord.
That is why, that's why I'm asking, what
Already
is
stated.
the object of your submitting that I am for respondent number 4? There must be some purpose.
Lordship. I have.
We know
submitted
that
for
you have
tender.
submitted, you have filed a vacating order because you want an intending tender. Isn't it?
Lordship.
Now, what do you want to say today?
And in terms of the interim order, they enjoying
That we know, that already been deliberated.
lordship.
Now,
That
what
is-
you want today?
I want to interim order may be vacated because earlier 3 days that.
And
interim order was
have you
filed.
heard the deliberations in the meantime? That matter is fixed on 13. We are dictating that it is be listed 13.
इस तरीके को read होगा इस तरीके को read तब सब जी होगा देखा देंगे Okay.
WPC 3663 of
3663
3663
3663
2024.
2024 on 38th of
These are all fixed on 30,
30th.
along with other petitions.
Okay. List along with children. Okay.
No, this actually issue was there because there was a stay order and the same court passed the stay order in the other case. So that when the matter come before that court, that was issue was there. That is why.
Yes.
Can start at 2 o'clock, only
At
3
2.
minutes left.
At 2.
Yes.
At 2. That matter.
Yes.
This is which matter? No,
Make Mallar, that
Make
permission.
Mallar, or you have another matter?
Yes, sir, both I'll do.
I think we'll intimate Mr. Chaudhuri will take up first that matter because that you are having an urgency
Yes.
in that matter.
Yes.
So we'll finish. How many matters are left? One is Arunachal already there, election, and how many matters? This Ken Chaudhuri's matter is 1.
2 Miller.
2. And then just a minute, let us understand. 50 supplementary list. Okay, 58 is it may go later part. Then yes, Mr. Das.
Lordship.
But no, what is your matter?
That land compensation matter, your lordship on the last occasion asked the government whether 3 pertinent questions were asked, whether I'm entitled for that compensation. They filed their affidavit and they have stated that yes, I'm entitled. Only disposal is required to the matter. If the lordship is having any matter at 2, then your lordship can fix it on some other.
No, we will not fix right now. We have 2 matters. How much time will take
My
in?
lord, in either, in Meghamallar, I'll take maximum 20 minutes.
Okay,
And this matter also 20 minutes.
2024. So please wait for that. And Meghamallar, he will conclude his argument.
Yes.
He will conclude. Then we'll fix this matter on first.
Advocate KP Patak will not be available in November, my lord.
What November? We are saying it is.
Oh, my lord.
And on first, we will like to have the senior counsels, both Mr. Chaudhuri and Mr. Advocate General in the court. So therefore, if anything question arises, in the meantime, we will go through it. Any questions arises, anything we will ask you both in presence so that you can respond simultaneously. Then if possible, we'll deliver the judgment on 4th. And if there is pressure, not possible, then after vacation. So this is how I have planned. Without planning, you cannot execute anything. So this is the plan. Today I will conclude nobody's presence is required. We'll note down his. Thereafter, already everybody's argument I have dictated. That part is over. Facts I have synchronized all the facts which are on record, which are not on record. Meaning thereby not on record means those are reflected in other cases where writ petitions were filed by the Unnayan Committee and all. Everything I have synchronized a date, and therefore anything is required, we'll ask those questions on fast. So this is how we are planning in Megha Mallar. Now, so far relating to that Nibonwa or something like driver.
Yes.
That will go to the yes.
Not a long matter.
Long matter, yes.
Yes, Your Lordship.
At 2?
At 2.
He will be available online?
Yes.
Okay. So before that, which matter will take up?
60.
Can we take up Mr. Das's matter and make him free?
Yes.
Huh? So ask him to come at 2.
Yes.
Then we'll go for all this hearing. Then we'll take this Nibonwa, then thereafter Megha Mallar. If we do not want to take Megha Mallar, we can take any day tomorrow. Tomorrow, day after tomorrow, anything.
Today.
Hopefully this time.
On this matter, I would have said. Because there is not much to
Much.
say, Miller. Only 2-3 points has to be clarified.
Now thing is that at least I think we'll be able to complete this method this time.
Yes, certainly. Certainly.
That's all. What hearing? Where is hearing? Tell us. Before vacation, who is for 57? Yes, what is the issue?
Here, the petitioner is the L2 bidder, my lord. Petitioner is the L2 bidder.
In respect of?
My lord, NIT issued fight dated 12.
No, settlement of what? Settlement, work order?
Settlement of work order, my lord.
What work order?
Issue of work order, my lord.
Work order relating to supply, construction of buildings?
Construction of road, my lord.
Construction of road. Road is constructed already.
No, my lord, there is an interim order passed on 4/12/2015.
Who is for the department? Okay. Yes, what are the issues?
If Lordship goes to the last order, Lordship, the specific order was passed to file affidavit by the land records.
Now filed or not filed. Just tell us whether we can go for final hearing today or not.
That affidavit is necessary, Lordship.
So then it will be difficult. But at the end of the day, it is a road project. We must be concerned.
Yes, Lordship. It is a matter relates to compensation, Lordship, nothing else. Two
Compensation.
persons are there.
But road is construction is stalled. If only relates to the compensation, where is the meaning of stay?
The Assistant Commissioner Land Acquisition shall file an affidavit incorporating the following facts.
Yes. The affidavit directed to be filed by respondent number?
Assistant Commissioner Land Acquisition.
Assistant Commissioner Land Acquisition has not yet been filed. Full stop. Learned Counsel representing press for an adjournment. Prayer stands allowed. List this matter when? Huh?
Item 57. 57.
57. Okay, we'll take up at 2. We'll see this. Yes, Mr. Deka. On board. Items?
PHC was directed to obtain instructions.
We have received instructions.
That connection.
This connection of water supply to the.
Then what happened to that?
Here's the issue is that the scheme, the PHA is only responsible for the building of the infrastructure of the tank. But the whole scheme is done by the committees. The PHA has very limited access to it. The disconnection, there's a difference between these two committees. That's why the consumers are suffering. The only issue, there's a difference in these two communities.
Who is supplying the water to her?
Right now, the existing committee.
You can't give her.
Lordship,
Don't say that will not give water.
no, Lordship, at least this matter may be here when my senior is there, Lordship. He's on legs, Lordship.
Who is your senior?
He's a second, Lordship. He's on legs in port number 15, Lordship.
So call the first dismatter at 2.
Lordship.
At 2, call this matter, then we'll see the what happened to this affidavit because hearing is not going to be held. Then that matter, thereafter we'll call this Arunachal and all.
I'm sorry, Lordship. In item number 57, Lordship, I have received instruction. Lordship, sometime, Lordship, I'll file my affidavit.
Okay, in 57, Mr. Nayak, learned counsel representing PWD, prays for an accommodation to file the affidavit as he has already received the instruction. Prayer stands allowed, list this matter on 21st of October 2024.
Next week.
28th of October 2024. In the meantime, affidavit may be filed. Yes, next, anything?
Your Lordship, item number 32, it was already mentioned in the morning, but there was an interim order, so.
Okay, 34 interim to continue. And some a boy came at item number 12, something like that I did not permit.
Continue.
What's that? What is the item number?
Item number 32.
Okay, Mr. Counsel, Mr. Batra, we'll first take up this matter that water supply first. Only 3 matters are 3 matters remains. Not 4, 5, all are connected. Actually 3. One is the KN Chaudhary's method. First this water, one. First is water, then Didas. Megamollar later on. Then I Chaudhary. Okay. This will be the sequence. Yes.
My learned friend missed that item number 12. He was here only. He went to inform me, and by that time the lordship.
What is this matter in?
Matter relates to, my lord, an inquiry was initiated against the petitioner and others, my lord, on the basis of one audit report, your lord. In that inquiry, my lord, in the Vigilance Department of Government of Assam, there are official memorandum, my lord.
But that memorandum was subsequently modified. Then,
but that in that modification also, my lord, so far as my lord doing the regular inquiry, your lordship, and preliminary inquiry, that was not changed, your lordship. That I will show, my lord. And my lord, before, after
okay,
that,
not today, not today. You inform Mr. Gogoi. K. Gogoi. Before now. K. Gogoi will take it up this matter some other day before vacation.
Before vacation.
We'll pass an order. Okay.
DPO.
Thank you, Lordship. What is happening here, Lordship, the Department of PH.
What is the earlier interim order?
Interim order, Lordship, you find, Lordship, in my affidavit. The first interim order, Lordship, you will find at page number 58.
Which matter?
The first writ petition, Lordship, 3326.
3326
page 58 is the affidavit in the affidavit, Lordship. Because I am reading the bylaws of the PHC department because they are repeatedly saying they have no authority because they have to control this committee, Lordship. This is the first order, 26th of June 2024. Now, after passing this order, Lordship, the PHC department forthwith they have resumed or restored the disconnected connection. Now, thereafter we continue, but suddenly, Lordship, the respondent again, Lordship, disconnected some of the consumers of the localities, Lordship.
Oh, region, who is the representing?
They are saying that, Lordship, we are running the society from 2012, but the bylaws says the committee should be a registered one number one. That is the first condition. Second one is the term of the committee is only for 2 years. Third one is if any dispute arises, then it is the superintendent of engineer of PHC. He will control the entire system. Lordship, may kindly have the bylaws. It is very much clear, Lordship.
Where is that?
It is in the affidavit.
Affidavit file in?
Affidavit file in 3326, Lordship. That is I filed petitioner file. Page 68. The vernacular, Lordship. Page 68. Operating portion, page 60. First one is the application, page 71. Plus, this is serial number 3, committee Karjaka, 2 বছর.
Then Lordship, see, this is important. They are saying we have no control. 13.1. Karjakari Committee Gothon Aru
Page
Page 71.
Page 71. Clause?
10 Doh Po.
Okay.
কাৰ্যকৰী সমিতি এখন নিম্নলিখিত সদস্যৰ দ্বাৰাই গঠন আৰু পঞ্জীয়নভুক্ত হ'ব লাগিব. So accordingly, we registered and we have been given this charge with effect from March 2023.
That
Now,
is what we are thinking, that a project will be constructed from taxpayers' money. And the department will come and say, we don't have, we have,
We have this role of
I'm coming to that, Lordship.
issue, means running the technicalities of the
No.
scheme thereafter, because I've submitted written instruction laws which I've submitted, whereby it's clearly stated the points are given here. Two committees are formed. Now the issue is that one committee is saying we are running, the other committee is saying no, we are running.
Forget about that. See, let us not go to in-depth of this litigation. Answer this question. By whose money this project is prepared?
From the local people.
Money taken from whom?
These are
The investment made in the water supply is from whose money?
On public, your lordship.
Huh?
Public.
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 For whom?
For the
For a locality. For a locality.
Yes.
It is whose responsibility otherwise to supply water?
Committee.
No, forget about the committee time being. Generally, whose responsibility to supply water, give water supply? Because as per our knowledge, Union of India and the state are declaring that there will be door-to-door connection in every household in India. Nobody will be deprived of good potable water. This is the principle. Now that water is to be provided by whom?
PHE, lordship.
PHE, or we are not saying PHE, by the state?
State.
Maybe you take some taxes, you may take some amount money for billing, whatsoever. These are the modalities. Now, your responsibility as a state, you delegate it to somebody else. It is not a case that you have taken money from a private player and you have constructed and handed it over. Okay? So you have delegated your own power to a private party. Now there is a dispute between who will run the society. There is a fight between them. Do you propose to say that you will be mute spectator?
No, lordship. We
Then
cannot be
tell
mute
us.
spectator. At this point, I'll submit that, lordship, that these two committees, since there's a dispute, will let the PHE take over that water supply scheme, your lordship. Let the PHE run it, your lordship.
Yes, we are passing that order.
Let the PHE run it.
We are passing that order in the interim and restore the connection. That's all.
Kindly see page 75. They are repeatedly saying they are no authority. Page 75, clause 17. সকলো ধৰণৰ পানী যোগানৰ সংযোগ নলী, that is the water connection, আদি নিৰ্মাণ কাম clause 17 page 75. সকলো ধৰণৰ পানী যোগানৰ সংযোগ নলী আদিৰ নিৰ্মাণৰ কাম-কাজ জনস্বাস্থ্য কাৰিকৰী বিভাগৰ তত্ত্বাৱধানত থাকিব.
It's like that electricity bill collection by the APDCL, giving some local authorities
some power
and they are given that you collect this, give us this percentage is yours. You cannot say like this. Yes, Mr. Sekya.
Now look at page 24.
No, for a time being, wait for something. We'll hear it later. Later we understand to hear Mr. Sekya. You are representing whom?
I'm representing the response number 11.
And who is the other committee?
They are the one committee.
They are one committee.
Our committee.
And you are the customer. Okay. Who is running the show as on date? And according to you are running. Huh?
They
The connection we have provided.
Okay. And according to you are running. Okay. So what is the reason for disconnection?
So far as the
forget about Mr. Deka for a time being.
No,
his case is something we'll take later on.
No, pursuant to this interim order, we have restored the connection. Though they were defaulted, they did not pay, and even after not giving connection, they are not paying. But then those connections are restored. 8 connections. 8 connections have been restored.
Now who?
So far as the other petitioner is concerned, she never applied. She tried to forcefully connect herself on the night of 13. we have also, immediately we have lodged an FIR. Later apply to us and pay the dues, whatever is there, we definitely on payment within 40 years, we can restore it.
Yes, what is your case?
Page
Huh?
16, I have already deposited the requisite amount, my lord. Page 16 in my case. On 11, I have submitted
Page 16 of the
my writ petition.
your writ petition. Item 62 4755.
We are not made party in this petition. but copy
Page
was-
page.
Page 16. I have obtained the connection from respondent number 12. That is the committee who is running the water supply scheme. And thereafter, my
So you have deposited money in favor of Mr. Dekha.
Yeah.
So he is saying we have not received. Third, we are passing an order to ensure him to pass the thing, and we do not know who is to be paid money. We do not know because he is saying he can you give connection to him?
Provided him, Lordship.
connection has been provided. After 1 day, they have disconnected.
My lord, can we see one document?
No, we understand.
Can you once
Yes.
one document, my lord?
See, let us, we'll hear you. Just before that, I am telling you one thing.
Page
We are not going to hear who is the actual committee who has authority to pay or receive money as on date. Since that is a dispute, that will be subject to the outcome of the writ petition. Restore the connection whosoever. That's all.
Superintendent will ensure the restoration.
Restoration.
And there will be no hindrance from any of the committee.
Any of the committee. Yes.
My lord, can you see one?
Page 24, this is the letter of the PHE. They have given this card. Page 24 of the writ petition. Should we hear the matter in the meantime? Let the file affidavit.
We can hear this matter today also, no problem on this. If the PWD stand is clear, PHC stand is clear. Huh? No, if your stand is that we cannot allow to be public money to be wasted to these people. Dissolve their committees. Dissolve the committees. Dissolve their committees and run yourself until and unless this dispute is resolved. Yes, it's up to you. Because he is also claiming, he is also claiming. In the meantime, people, consumers are suffering. So we will decide, they may decide in civil court whatsoever, whatever loss income, we do not know, pay the money to PHE and PHE will restore.
That's true, Lordship, but Chief, since Lordship.
Who are you? Well, we are not here to decide your committee's dispute.
But it is the PHC who is Lordship entrusted us. They have given the authority. Page
They will,
25.
therefore, they will decide who is the actual committee. Let them decide.
Page 24 is the order. That is why I'm trying to.
The owner of the project is no doubt PHC on the basis of taxpayers' money. They will decide whom they will allow to run or whom to not. As simple as that.
Just one mallet.
Yes.
Full of mallet quotation in the statement made in the writ petition mallet. So as first is concerned, only one page mallet can be found at page 30. This is a representation to the executive engineer PHE. Starts from 29. That may directly come to page 30 and the last portion. This is dated.
Which page of which writ petition?
3326.
3326 we are not taking up.
3326. The other one copy has not supplied. No, we have been made party.
Okay, that is not that you file an application for implement or will dismiss. If we hold that you are the authority, we will dismiss their writ petition on that ground. But for the time being, we are asking PHC to ensure that water is given. We are not asking him to give or you to give connections. We are asking the PHC to ensure.
Before only one document of the writ petition 3326.
Yes, I am with the writ 3326. Yes.
Page 29.
Yes.
It is dated 3/5/2023. Now the lordship may directly come to page 30. The last portion. We, the committee member of Navajyoti Nagar Khwapani Jugan Asoni Porichalona Samiti, requires you to kindly arrange to physically hand over the charges of so-and-so Nagar to us and on urgent basis. They have not yet taken over the charge. We have been running it from since long.
Hard, Mr.
And it is admitted that you kindly see.
No answer is required. We are not going to answer all this. We are just record your submission. Hard, Mr. It will be written in WPC 4775. Hard Mr. You are for Sharma, learned counsel for the petitioner. Also hard Mr. Gogoi, learned standing counsel for the PHC department. The basic grievance of the petitioner is that the water supply connection given to her has been discontented by respondent number
9, 10 and 11.
9, 10 and 11. That is Mr. Deca's client.
I'm 12.
Huh?
12.
I'm 12. Lordship.
9, 10 and?
It is
My senior
He said that no.
We have not given any copy, madam.
9, 10, 11 is represented by,
Okay.
by name there. Notice has not been issued in this.
Okay. Okay. 9, 10 and 11. You are appearing for 9, 10, 11? Not cannot. Okay. 9, 10 and 11. 9, 10 and 11. It is the case of the petitioner that the petitioner has deposited the required fee for connection water supply connection by which before to respondent number 12. Respondent number 12 society, and accordingly the respondent number 12 society has granted water supply connection. However, at the behest of respondent number
11, 12. 9, 10 and 11. 9, 10 and 11.
9, 10 and 11, the said electricity has been discontinued. It is opposite. It is important to note, record, not opposite. Important to record here in that WPC 3326 2024 has been filed by respondent number
12.
12.
Respondent number 12. Inter alia praying that what is your prayer?
Prayer Lordship page 18, 17.
Inter alia praying that
Hand over the key of the 5 water schemes, so and that is therefore the rest of it.
inter alia praying that writ of mandamus should be issued to respondent number 1 to 5. That is the PHE department.
Yes.
Huh? That is the public health engineering department to hand over the key of pipe water supply scheme, comma of Nabajoti Nagar, Panjabari, and to allow the petitioner society to collect monthly water supply fees from the consumers and deposit the same in the joint bank account maintained by the petitioner society. It is important also to record that the water supply scheme for supply of potable water to the residents of Nabajoti Nagar was constructed by the Public Health Engineering Department, and to run the aforesaid scheme, the same was handed over to a committee headed by respondent number.
No.
Page 25.
You respondent number.
In my case, 9, 10, 11.
We are not.
In your case, I'm saying by the respondent number 9,
10 and 11.
9, 10 and 11.
By the committee headed by 9, 10 and 11.
By the committee headed by the 9, 10, 11. Respondent number 9, 10 and 11. Whereas in the writ petition WPC 3326, the petitioner claims that after expiry of the period, the new committee has been formed, and it is the legally authorized committee, that is the writ petitioner committee, who should run the scheme. However, as the same was not handed over to them by the respondent number 9, 10 and 11, the said writ petition is filed. In the aforesaid backdrop, it prima facie appears that there is a dispute as regards who should run who is the actual committee, whether the committee headed by respondent number
9, 10 and 11.
9, 10 and 11, or the committee headed by petitioner, or the committee who has filed writ petitioner, that is WPC 3326/2024. This is the case. 22/2026. Full stop. In a considered opinion of this court, and it's a prima facie view that the water supply project has been constructed by investing public money by an instrumentalities of the state, that is Public Health Engineering Department, and for smooth running of the such scheme, a committee has been formed. Therefore, the dispute between the members or two committees cannot be a ground for disconnection of any electricity, the disconnection of any water supply disconnection. Full stop. It is seen that the petitioner herein has recognized the committee to be the actual committee in WPC in WPC 3326/2024. At the same time, the petitioner in WPC 3326/2024 itself praised that the project be handed over to them. On the other hand, the respondent number 9, 10, and 12, 9, 10, 11 claims that still they are running. Therefore, in the aforesaid view of this matter, and considering that the owner of the project is the Public Health Engineering Department, for the time being, as an interim measure, it is provided that the project be run by the Public Health Engineering Department in their department, and accordingly restore the connection consulting the record of the customers. Full stop. In the meantime, if any resolution of stalemate is there, that can be intimated by filing an affidavit by the PHE department.
May I pray one more further? Can the PHE department be directed to make an inquiry to the
So they will do whatever. It is needless to say that the PHE authority, PHE being the owner of the project, they will at liberty to reconstitute the committee or make any inquiry that may be necessary for this purpose.
Online 6th of March 2020, they handed over the.
No, we are not. No.
Because of
Okay,
this order,
then it is in fact not handed over. However, so your petition has become infructuous. We'll close it. We'll close it. We'll close it. You have said you hand it over. You say already hand it over. We'll close it. It's as simple as that.
The actual key why who is.
No, we do not know.
Lord. Then I can call him.
We know you are both are fighting for the power.
How much fictitiously they have come. This is
that's why we want to find inquiry.
But writ petitioner is different, registration is different.
We understand, but we cannot allow. Ultimately, this is a writ court. We cannot allow you to run like this. So it is a owner is PHE, public money. Let them run it as an interim. No committee. You run it. I have made it clarified. And if you are at liberty to reconstitute, dissolve, whatsoever you like. That has been granted. You will ensure.
Subject to payment. You say subject to payment, but that will PHE will look into it.
It will list this matter after November, 7th of November. So any date, 7, 6, 8 November. Not 8. 8 is a difficult.
Item 1.
Just a minute. Yes. Yes, Mr. Singh. Who appears? Please tell us.
My lord, I have just received an affidavit filed by them seeking some 4 weeks time to file counter. That I have
Written
just
statement file.
No, that file. Seeking time to file. Seeking 4 weeks time to file.
Seeking 4 weeks time to
by the sole respondent. I have just received it.
Sole respondent. Sole respondent. It is submitted. This matter is taken virtually from Itanagar bench. Full stop. Mr. M.G. Singh, Learned Counsel for the petitioner, submits that an application has been filed by the sole respondent seeking time to file written statement. Is it correct?
There is praying 4 weeks time. That is the cost.
Praying for?
they are praying for 4 week time to file reply to election number petition. That is
Reply
correct.
to?
An application praying 4 weeks time to file reply to election petition 1 of 2024. That is what the post
That
like
is
that.
written statement.
Yeah.
Reply
So-
to prayer is allowed. Mr. Singh has not objected to such prayer. Accordingly, prayer stands allowed. Full stop. List this matter on give a date, convenient date.
My learned friend will give because he's appearing for
Yes, yes.
sole respondent.
Your Lordship, any date will be due, Your Lordship.
No, you are not
After
getting
4 weeks, Your Lordship, after vacation, Your Lordship.
we do not know, but after 4 weeks, maybe period may be over 90 days. That's why he's like he has happily agreed. It's not that we are saying that subject to the time period prescribed, we will allow it. That's why he happily agreed. Are you aware of what is the procedure required to be taken in election petition? You are representing the speaker or what?
Sole defendant, Your Lordship. I am representing a sole defendant.
Elected MLA is a minister.
A minister. No, minister, no minister.
Different candidate, different
MLA,
candidate.
Your Lordship, MLA.
MLA, do you know
Yes,
the
Your Lord.
implications if you do not file within 90 days from the date of receipt of the written statement?
Yes, Your Lordship.
You know, okay.
Yeah.
Okay. List on, give it it. So casual, all are.
Let my learned friend
Petition,
decide
petition.
that. My learned friend said that because he's supposed to file.
After 4 is give a date.
23 of October.
Lord.
How much?
23rd of October, Your Lordship.
23rd of October 2020.
Obliged.
Hello.
They will not help you anything, huh? Okay, okay.
Obliged, Lord.
Yes. Yes, where is the affidavit? Please just remind us what was the issue.
My Lord will kindly peruse the last order, my Lord, and 29/8/2024, page 3. From the materials available on record, it is seen that the Assistant Commissioner Land Acquisition Office, Jorhat, has already page 3, my Lord, of the last order, my Lord. Your Lordship.
No, that we have seen.
Yes.
Affidavit.
Affidavit, my Lord, page 98.
Page 98.
Para 12.
Any private respondent here?
Private respondent is there, my lord, name shown.
Last
My lord, they did not appear.
They all did not appear.
Yes.
Name shown in the list, Lord.
Which paragraph?
Para 12.
Para 12, page 98. There is no para 12.
This is the affidavit of respondent number 5, my Lord, Salah, Competent Authority for Land Acquisition.
Respondent number 3.
5.
5.
Lord.
What?
Is a file on my lord 19.
Yes.
Okay. Okay. Paragraph
Paragraph
12.
That with regard to the court's order date, Honorable Court's order date 29/8/2024. Number 1, yes, the petitioner was entitled for the compensation for structural damages. Number 2, yes, the facts narrated in the FIR lodged by the then Assistant Commissioner Jorhat are correct. The compensation for structural amount has been disbursed to the respondent number 8 as per 3G.
Now who will pay?
Yes.
Who will pay this amount? Whose mistake?
My lord.
This is the mistake of Kala, Your Lordship.
Lordship, now we have,
As
my
per
lord, that
3G,
is
we have
taken.
deposited the
My
amount.
lord, their
Is it
name,
intentional mistake?
no,
or-
no, no, no. The name are same. Only my lord, father's name are different. Only because of that, my lord, it has been.
Now who will pay them? Pay them. Have an instruction.
Lordship. We already
And
been, my
how
lord,
within how much period? This court under its order dated
29/8.
order dated 29/8/2024 directed the respondent CALA, is not it?
Yes, madam. Competent Authority for Land Acquisition.
To file an affidavit on the following points. Page 2 of that order, 1, 2, 3. Okay. An affidavit has been filed by the CALA, which is quoted herein below. 1, 2, 3. Page 187. You just correct your pagination from this.
Yes.
This is 187.
Yes.
Okay. Page 187. 1, 2, 3. In view of the aforesaid, it prima facie appears that the petitioner is entitled for the compensation amount as claimed and as claimed and sanctioned. Full stop. However, now therefore the question will arise: who will now pay the aforesaid amount? At this stage, Mr. Hendik and Mr. You are for the National Highways, huh?
For anything.
Learned Council for the representing Kala as well as NHA DCL seek some time on behalf of C. Borua, Learned Council Mr. C. Borua for NHI DCL and Mr. J. Hendik, Learned Council representing Kala, seeks for a week's time to obtain instruction.
Number 8.
Who are you?
Number 8.
You have taken the money. Then when will you pay it?
Well, that Lordship, in our affidavit, Lordship kindly goes to the page.
Yes, yes. When will you transfer it to?
8 will amend.
Oh, forget about it.
Paragraph number 6, Lordship kindly pays.
Paragraph number 6. We'll send you to jail. Be there for some time on the next date.
You are asked to appear before the ADC and he appeared and he assures that within a month, Lordship, he will return the amount.
To ensure it. This is not our business to ensure. We can do something, some coercive action against you.
Even then, Lordship,
who is the new counsel? That we cannot record. You are in difficulty. Even necessary, we will ask them to proceed in Bakijai proceeding or whatsoever and auction your property and ask him to collect your properties, pay them, and government will recover you from selling all those properties.
I already will talk with the that some officers regarding that procedures. Bakijai procedures, you should be.
We'll give you handle to recover.
They already been there is a bond, Lordship. That bond has been signed by that person, Lordship. You have to.
So that's why today time may not permit. We are fixing it before vacation given.
Lordship.
We're out of the record, not to be recorded. We expect that you deposit the money or give some undertaking here. As simple as that. Otherwise, you'll be in difficulty. 30.
10. 30.
309.
Like.
Yes, maybe Indrani Chaudhary maybe. Yes. We are on interim or final? Mr. Chaudhary, interim or final?
Same amount will be required.
I am ready for both.
Okay, let us proceed. Let us.
Yes.
See, two aspects. If we hear for some time and we decide that no interim, then automatically matter becomes instruction.
Yes.
If we hold that this interim is required,
Yes.
then entire matter can be disposed of.
Yes.
Either way.
Yes.
So this way dismissed, this way we can help. Yes.
Yes. Lord will kindly come to the reputation, Mila.
Your argument is it your argument that in the earlier policy of one person, one vehicle was only under challenge, not the policy of without tender.
Not the manner in which this tender is sought to be,
That can be the only argument.
Yes. It can't be there cannot be any other
Any
argument.
other argument. That can be because Mr. Chaudhary is saying that policy was tested and policy was upheld and it went up to division bench. That was also upheld.
Not avail.
It's not
No,
something
no.
like that. Let me explain.
Huh?
Milord.
No
That
interim.
policy, huh?
That
No,
policy
no
was
interim has been
challenged.
done.
The policy was upheld.
Uh,
So we are, Milord, for a moment, we are not challenging the policy of one
no,
individual.
therefore, that,
one-
that is how I structure it.
But writ appeal
Your
will-
writ appeal was against interim order.
no,
only.
refusal to grant it.
That is by the learned single bench. So for the time being, we are not going to the interim order time being.
Yes.
The fundamental argument beyond the earlier order is that even if it assumes that there is something on the flaw on the policy, that policy was already upheld by in another set of writ petition.
Yes.
So therefore, nothing to be
Challenge to
done.
policy
Now
cannot be there.
come. So your argument, I think, will be that whatever upheld was one vehicle, one person, not the policy of non-tender. This will be your argument.
Yes.
Let us proceed and let us
Precisely.
not expand to all this.
Yes. Please come to the writ petition. Milord. Now please come to page 46. It's part of the tender.
Of the writ petition.
Writ petition.
Yes. WPC 4108, isn't it?
Yes. Page
Yes.
46.
Just a minute, huh? Affidavits are there, therefore it has become bulky. Okay, page 46. These are new affidavits. Muslim just look into this. Huh? Mechanic silos on key affidavits of flag my idea. Huh? This is the writ petition. 48.
46.
46.
Yes.
Separate. Yes, 46.
And you see tender number, tender description, number of categories. Hiring of services of brand new 372 number of light vehicles, taxi for Assam asset for 4 years on lottery basis. And there are 6 categories, Milord. Total 372 number of vehicles. Now, if a lordship would kindly come to page 47.
Just a minute. Let me mark this. Yes.
Total 372 number of vehicles comprising of different brand and type. Then please come to page 47. Third heading, draft lots. Against the current requirement.
Which column?
Page 47.
Yes, 47.
On top,
Lottery date.
draft lot.
Lottery venue. Huh?
Lottery venue, then
Draw of
lottery date, then draft lot.
Just a minute.
It's too hot today.
And disadvantage is that you are arguing for 15 minutes. We are speaking from 10:30.
But you know, the movement from one court to another, that is also very taxing.
But it is very good.
Good. Health-wise. Against the current requirement of 372 vehicles under tender, a total of 500 applicants will be selected by the first round of draft lots. The first 372 would be ranked as the shortlisted applicant and rest 373 to, that is 125, sequentially ranked as waitlisted applicant category-wise. So, my lord, only way to shortlist the candidate is, my lord, draft lots. Then, my lord, will kindly come to page number. Rates and all are also given. If your lordships will kindly come to page 48.
48.
The rates are already there, unit rates, page 48. Applicable rate for category. Mahindra and Mahindra Bolero B4 diesel. So rate is also given. Similarly, up to page 49 in respect of shifts, different types of vehicles. Then, my lord, will kindly come to page 51. 2.2 towards the bottom. On login to the application system and after verification of the registered email ID and mobile number, the applicant shall enter the following details: full name, father's name, gender, employment exchange registration number, name of the employment exchange from where card has been issued, validity date of employment exchange, date of birth, and Lordship may kindly skip those keys, come to the last one. Applicants falling under 8 to 55 years on the tender original closing date will only be allowed to participate in the tender. Lord, from a cumulative reading of all this, what follows is all that an applicant is required to be, he must be registered with the employment exchange. And secondly, my lord, he must be within the age limit of 18 to 55 years. No other qualifying criteria, nothing is there. Then my lord will kindly come to 3.0 on the bottom. Brief selection procedure for award of contract. Now, the competition is confined to 4 districts. This is also not correct. Then
No,
C.
please together mark which are under challenge conditions, sir, in this repetition.
All that is under challenges, we are challenging the NIT as a whole.
As a whole.
Yes, all that we are saying is it lacks the attributes of a tender.
Okay.
A draw of lot cannot be equated with tender. That is my case, Miller.
Okay.
Then Lord will kindly come
So
to
just we can record it. This is one of the offending that no qualification is there. While your argument
yes,
is
yes.
That's why I'm asking.
Especially referring to Lord, page number 51 and 52.
That is that is
These are the
only criteria.
And selection procedure, if you kindly come to page 53 also.
Confined
What
to a
is required is
district.
self-attested copy of.
So it is also under sense confined to district.
Yes. This all personal information of the applicant. There's nothing to do with either the experience of the bidder or the financial capacity of the bidder. These are not being tested. Then Milord will kindly come to page 108.
Just a minute.
Sorry, 109.
109.
Yes. Special terms and conditions. Please come to 13.
09. Yes, 108 or 9?
109.
Okay.
Serial number 13 towards the bottom of the page.
Self-driven.
Light vehicle have been classified into 2 different categories, self-driven and ownership. Self-driven. Light vehicle shall be driven by owner himself throughout the contract period. Owner has to give written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect. So in respect of self-driven vehicle, there cannot be any scope of engaging a driver. The owner himself has to drive. B. Ownership. Light vehicle has been awarded to contractor. Contractor may hire another driver for hiring the vehicle. So a ownership means a person, he may be owner, he may not be self-driven, he may engage a driver. So this is the scheme of the tender. Now, the stand of the ONGC is that the policy was tested in an earlier repetition. Therefore, the challenge is not maintainable. Now, if a lordship would kindly take their affidavit, the affidavit take on. Please come to, my lord, the affidavit filed by ONGC.
It is any page number or file today?
No, it was filed on 60, copy was given to us on 16/9.
Okay, okay, affidavit.
It starts from, my lord,
That's
page
one number
176.
2, 3 and 4.
Yes, it starts from 175.
It starts in our page from 174.
Okay, okay. Then I think the index starts with
175,
Yes,
175.
yes. My lord will kindly come to page 208.
208. Yes.
Lordship may kindly come to 207.
207.
Minutes of tripartite meeting held on 8/8/23.
Just a minute.
Minutes of the tripartite meeting held on 8/8/2023 at 4 p.m. in Sukapa Commercial Hall, so and so, so and so. My lord will kindly come to page 208. Basically, Deputy Commissioner was there, the tenderers were there, and my lord, ONGC authority people were there. After threadbare discussion on all issues, it is decided that tender for single vehicle will be accepted for single individual through lottery. Experience certificate issued by commercial vehicle owner will be accepted for the drivers. Now, condition of GST is noted 4. Equal weightage will be given to all qualified tenderers. Kindly come to the last subpara. Further, the district commissioner requested the ONGCL authority to review the matter at their level and come out with a rational solution that genuine demand of unemployment may be addressed. So what transpires from this minute is, my lord, I think there was no consensus. Therefore, the expectation which was recorded is that the Deputy Commissioner requested the ONGCL authority to review the matter. So what was sought to be done? There was a request for review of that. Therefore, to rely on this minute, it is neither here nor there. And my lord will kindly come to page 209. UPC to teaser. Please come to 209, my lord. This is a communication dated 19/9/23. Evaluation of tenders for hiring of light vehicles in Assam. EPC in its meeting held on so-and-so reviewed the evaluation of tenders for hiring of light vehicle in Assam and decided hearing of light passenger vehicle on one application, one vehicle basis at the rates offered by ONGC using draft laws. So, my lord, disregarding the request of the Deputy Commissioner, they decided to go for one. That is not the issue. Issue is using draft law. Now, my lord will kindly come to page 210. Yes, next page.
Just a minute.
Now, 3. Draw of lots to be held among all applicants in presence of applicant, parties, and the member of the indenting department, finance department, and MM department. Then my lord will kindly come to page 212.
Yes.
No, this is very important. Assam Asset Cell Frame BEC detailed tender clauses in consultation with Oil India Limited, and same shall be approved by concerned L1 executive. Other work centers in Northeast may adopt BEC bid evaluation criteria tender clause finalized by Assam. So draw of lots would be the eventual, but there will be a bid evaluation criteria. So the note assumes importance in this case. So my humble comprehension or little bit of understanding is that it did envisage some criteria, my lord, to determine the eligibility. So which is absent. Now, my lord will kindly come to page number 218. This is that earlier order on which they are relying again and again. Page 218, para 11. In case of so-and-so versus West Bengal Transport Infrastructure Development Corporation, the Supreme Court has held that government policy can be changed with changing circumstances, and only on the ground of change, such policy will not be vitiated. The government has the discretion to adopt a different policy or alter or change its policy to serve public interest and make it more effective. Choice in balancing of the pros and cons relevant to the change in policy lies with the authority. But like any discretion exercisable by government or public authority, change in policy must be in conformity with reasonableness, and it should be free from arbitrariness, irrationality, bias, and malice. In the present case, there is nothing to show the change in policy by respondent for applying one vehicle, one applicant principle is unreasonable, biased, and arbitrary. Change in policy for awarding the contract work on principle of one vehicle, one applicant was made on the basis of the minutes of the tripartite meeting held on 8/8/23. In my humble submission, my lord, 8/8/23 tripartite meeting did not result in any consensus. Anyway, my lord, this judgment is not under challenge. So I have referred to the judgment to show all that the Honorable Court upheld was the policy of one applicant, one vehicle. That is not our challenge. So, my lord, I have shown from page 212 from the note where it clearly says, now, my lord, that some de-devaluation criteria have to be there. For example, my lord, those who fulfill the de-devaluation criteria, therefore, for picking the ultimate, if you apply draw of lot, that may be a different situation. But without anything draw of lot, it will not have the essential element
So
of
the
a
substance
tender.
is that without any criteria, only the draw of lot will not be applicable. It will be arbitrary, or even there are some criterias on the basis of which you draw up lot, then it would have been a different.
Just now, while arguing, it struck my mind. I think I would have got something from that Competition Act also. Why do you say, my lord, competitive bidding? If draw of lot is to be applied, can we say that it would be competitive bidding? The expression often we use is competitive bidding.
Yes.
Competitive bidding has its own legal connotation. It can't be equated with a draw of lot. Now, my lord, in the affidavit, they are relying on some document, tender issued by Oil India, where, my lord, they have resorted to draw of lots. But that was, my lord, prior to this tender. There are subsequent tenders by Oil India where all de-devaluation criteria and everything are there. So, my lord, this is as much as the affidavit is concerned. Now, we have filed one, my lord, additional affidavit. Please come to that. It starts from page 337.
Just a minute. Yes.
If your lordship should kindly come to page 378, it is part of the affidavit filed by ONGC in the earlier petition.
Page
378, para 11. In the earlier round of litigation, I'll just refer to one passage, my lord. Somewhere in the middle, the sentence starting with "and therefore to resolve" at page 378, para 11, somewhere in the middle, and therefore to resolve the prevailing situation. Line about 13 from top.
And therefore to.
And therefore to resolve the prevailing situation, the higher management of ONGC has decided to adopt the model of Oil India, Oil Duliajan, Assam, which is operating successfully, especially for hiring of light vehicles in Assam. So they, in their, this was their stated stand before this honorable court that they are following the Milord oil pattern. Now, oil pattern NITs we have annexed. Please come to page 391. This is a tender of 18,524.
Yes.
Only scheduled date, my lord, 18th of May 24. First subpara. In connection with its operations, oil wants to hire the services as mentioned in tender document on one applicant, one vehicle basis, for which bids are invited with requisite documents as indicated in the tender through its e-procurement portal. Then my lord will kindly come to page 406. It's part of the tender. Clause 2.2. It speaks about bid security, my lord, like any other tender. Then my lord will kindly come to page 412. Clause 8. Page 412.
Yes.
It speaks of, my lord, technical bid, unpriced. It speaks of commercial price bid. Then my lord will kindly come to page 413. The heading is how technical bid and commercial bid will shall be submitted through e-tendering process. Bid price is there. Then my lord will kindly come to 416. Was the bottom, my lord, 24.0.
Yes.
Opening of commercial bid, price bid. Then my lord will kindly come to 417. To 25, evaluation and comparison of bids. 20.27, award of contract. Then my lord, page 433 is very important. Bid evaluation criteria. How bids should be evaluated. So this is a tender. They say they are following Oil India, and this is the what Oil India is following. So it's a complete tender which entails competitive bidding. Now, my lord, today, my lord, they have filed an affidavit. I'm very sorry to say, my lord, they have resorted to falsehood.
Which affidavit?
Yes.
In IA?
Yes. In the IA. Now, if your lordship should kindly come to the IA for a moment.
Page starts at 330.
I'm just placing, one second. One second. So many pleadings.
So many pleadings, that's why.
So nowadays, at least, my lord, this continuous pagination has introduced some, my lord. Anyway, if a lordship should
I think this will be 330.
Yes. Page number. Yes. If your lordship should kindly come to page 28. 28.
Page 323.
IA 2936.
IA 2936. Give the IA.
What we have challenged, my lord. Yes. Oh, I'm sorry.
IA 32.
Yes.
Yes.
No, my lord, 2936.
IA 2936.
Yes,
Page.
page 28.
Yes.
Now kindly mark the date, my lord. 15/9/24. Now, according to this notice, draw of lots will take place, will start from 19 and end on 24/9/24. And lordships had taken judicial notice of this, and that is how the matter was fixed today. Now, today they have filed a reply, my lord, where they are denying the existence of this document. Just see what they have done. Now, if a lordship would kindly come to that affidavit in that IA, para 10,
Samiran Bera, Bora or something like that. District Commissioner. District
no,
Commissioner.
my lord, that is by the deputy
Respondent
commissioner.
number 2, 3, and 4.
Yes, 2, 3, and 4.
Yes.
Please come to page 48, para 10.
Page 48, para 10.
That with regard to the statement made in paragraph 4, the answering respondents, while categorically denying the same, beg to state that the applicant, in their overzealousness to somehow find fault on the act of answering respondents, were oblivious of the fact that notice for draw of lots and rules for draw of lots were published on 15/9/24.
Where are you reading? Paragraph?
Paragraph 10, page
As
40.
regards the statement made in paragraph 10.
No, my lord, 4. As regards the statement, with regard to the statement in para 4,
Para 7, para 6, para.
page 48.
Page 320.
My lord,
If
IA pages are numbered serially.
no, I think they have committed some mistake.
My lord, this is an affidavit in opposition filed by ONGC
Uh,
through our IA.
I'll be the respondent 2, 3, and 4.
Yes, 2,
Okay,
3, and 4.
I think this is so many pleadings. This is in repetition. This is in IA. By whom? On behalf of 2, 3, and 4.
Yes.
Page
48, my lord.
48.
Para 10.
Yes.
That with regard to the statement made in paragraph 4, the answering respondent, while categorically denying the same, beg to state that applicants, in their overzealousness to somehow find some fault on the acts of the answering respondent, were oblivious of the fact that notice for draw of lots and rules for draw of lots were first published on 15/9/24. However, the said documents were revised on 17/9/24 owing to change in schedule of the draw of lots due to non-availability of support from district administration, and the revised notice for draw of lots and revised rule for draw of lots were published on 17/9/24, and same notices are available on ONGC vehicle tender website so and so. It is further clarified that in response issued by ONGC on 21/8/24 to the vendor's query, brief explanation of the selection of application was given, which has been explained in detail under the rules of draw of lots, which has nothing to do with the tender conditions. Since tender or conditions mention conducting of draw of lot, the same has been explained through a mock session video through tender website. There is no change of any tender condition. The draw of lot for the notice for draw of lot refers to para 3F of the NIT and the tender condition. Details of the process is covered under current policy. Anyway, now, my lord, the purpose of me reading this part, para 10 was, an impression was sought to be given, my lord, that in our overzealousness to point out the irregularities, we have come up with that 15/9 thing notice. In fact, my lord, that 15/9 thing notice was very much, my lord, uploaded and we have
Now,
taken
what is
screenshot.
now what is the date, present date of drop lot?
Now, my lord, they have issued one notice where they have said, my lord, having regard to the fact that lordships is in session of the matter, I think a part of the thing has been kept in abeyance. This they have uploaded.
Okay.
If your lordship will kindly have this. This is also technically not correct, my lord. Out of the 500 vehicle, we have materials to show as far as draft lot relating to 450 is already concluded.
That was, I think, that because started prior to hearing of this.
But going by this as if they are not doing anything.
Anyway, let
Anyway,
us. This is
they have
not.
come up with that. So let us not go to those aspects. Now let us come to the merit of this.
So therefore, at least one anxiety of this court is gone. I need not deliver the judgment right now. we can deliver it tomorrow, day after tomorrow.
Now, my lord, I have referred to the judgment of Honorable Supreme Court in Michigan Rubber. Please have the judgment for a moment.
Now, Advocate General is here. You are also here. Tomorrow? See, what I was proposing, we are not here. Mr. Chaudhary was supposed to just reply your points
take long
by 20 minutes. And then I was planning it to fix it on fast, so that I can have any query I am having, I will ask both in presence of both of you. But today I think brain is not working any further.
Plus it's too hot today.
And already
Lordship's brain is not working. That is not acceptable to us.
No, see already how many matters.
No, it's okay. Lordship will take up
So
tomorrow.
therefore we'll take up that matter tomorrow.
Tomorrow.
No problem.
Your matter, so since you are sitting,
Yes.
That's why tomorrow your presence may not be required, but on fast we will require it.
Well, on the second half, tomorrow.
Tomorrow second half, of course.
At 2 o'clock.
On fast or whatsoever date suits you before vacation.
Yes, no problem.
On Monday.
3 तारीख को Monday, it will be Tuesday.
Oh, boy.
Tuesday. And on that, but we'll hear you tomorrow.
Yes.
And on first Tuesday, if no problem is there, then we'll just, if anything, any thing is required, then factual aspect, dispute,
clarification. No.
Then if possible, we'll deliver the judgment before vacation on 4th. And if not,
so that either party, whoever gets it against, they can prepare the appeal during the vacation.
Yes, instead of me preparing the judgment during vacation. So if not possible, out of pressure of vacation pressure, then we'll keep it on immediately.
So Lordship is shifting the ball to us during the vacation.
Yes.
Deeply obliged.
My lord will kindly come to para 23, my lord. The other day I read D. Today I will give more emphasis on A.
I guess, dear. Michigan Rubbers. Yes. Paragraph?
Paragraph 23, my lord.
23. On last occasion, you referred to
D.
D.
But I think, my lord, A is equally important.
Just a minute. Paragraph 23.
3 at page 229.
Yes, A.
The basic requirement of Article 14 is fairness in action by state and non-arbitrariness in essence, and substance is the heartbeat of fair play. These actions are amenable to judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of the reasonableness, it would be legitimate to take into consideration the national priorities. Well, at the end of the day, how do we ensure transparency? How do we ensure fairness? If, my lord, the necessary yardsticks are not laid.
Yes.
So draft lot, my lord, it can't assume the character of a tender. It's in a totally different realm altogether. I couldn't find any judgment, my lord, to be honest. Why not this should be the first judgment? Maybe it will be tested in Supreme Court. Now, my lord, I am posing a question to myself. What is draft law? Draft law, can it, my lord, can it be said that in a process where draft law is adopted, the competitive bidding is possible, my lord? Because there is no qualification criteria, there is no experience criteria, there is no financial part. Therefore, my lord, Article 14 always strives to ensure equality. How can equality be ensured? It can be ensured by adopting a procedure which is unfair. How can we ensure fairness? We can ensure fairness by following some code of conduct. Otherwise, my lord, there will be an element of discretion. And we all know, my lord, discretion, whenever it takes over, then there is an element of arbitrariness. That is why, my lord, in the Honorable Supreme Court says certain preconditions or qualifications for tenders have to be laid down to ensure that contractor has the capacity and resources to successfully execute the work. If everything is laid down, then all that is required is an employment exchange, registration. Normally, my lord, a person who would like to do business, he will not register his name with an employment exchange. A person who registers his name in employment exchange, his basic idea is to look for a white-collar job. So, my lord, there is no nexus between registration with the employment exchange and seeking some business avocation within government organization. End of the day, my lord, this all must have some ultimate connection. There is no connection. And kindly see the tripartite meeting, it ended in a basically failure. And the learned single judge in the idea round of litigation refers to that. When I am not on appeal, I am not saying that. And in any case, the judgment was rendered in a different context. So, my lord, it's not that, my lord, I have to repeat my argument.
Yes.
I am on a very narrow compass. In my humble comprehension, here is a case where ONGC's effort is not legitimate. They may have their own compulsion. End of the day, you are also an authority under Article 12. You are distributing state largesse. Now, when are you distributing state largesse? Why there's some element of competition should not be there? Without that element of competition, how can there be, my lord, fairness? So it is bound to be, my lord, counterproductive. Now, my lord, lordship knows there is also a concept called QCBS. They call it quality and cost-based selection. Now, in that quality, where, my lord, quality of weightage is 70% and quoted price has an element of 30%. Maybe 50-50, maybe 70, at least there is some component. Now, in this case, my lord, how do we judge whom to give this contract? Because draft lot is something else. I can appreciate, my lord, in a scenario where otherwise the eligibility is adjudged. Now it comes to whom to give the work. After that, my lord, eligibility and all are, my lord, adjudged. Then, my lord, there are more than one person with the same rate or maybe with the same experience. Then you adopt draft lot. Draft lot is a means to resolve an impasse, but it can't be a method of distribution of state largesse. That is my humble submission.
Yes.
That's now.
Yes. Yes, Mr. Chaudhary.
My lord, before I start, on a lighter vein, my lord, each of these arguments that have been advanced, had we been hiring rockets or spacecrafts, would have sounded very nice. We are hiring only taxis.
With all his satire always.
My lord will kindly come to.
When are you coming back?
I am stuck here. I am stuck here tomorrow, first half. Hopefully, I'll be back by tomorrow evening.
Day after tomorrow, we'll hear you.
No,
Voice is totally broken.
No, voice is broken.
Totally broken. And your picture is also like
Hazy.
huh? Not only hazy, it's like something is being you are hidden by some papers or something like that.
Hazy. When a person is not handsome, my lord, it is better to be hazy.
That will be ascertained not by us, by some others. Day after tomorrow.
Correct.
Okay, we have more or less understood what is Mr. Chaudhury's case. You have already taken a decision and hearing will be concluded on day after tomorrow. We'll deliver the judgment on day after tomorrow.
Yes.
Okay. That's why instead of hearing in this manner, we'll hear you in your presence.
No problem.
Third in part for further hearing day after tomorrow. You just keep the arrange, huh? This is Michigan rubber and click this. Also keep this. Just give in my chamber. Okay. We'll bring it by slip since it is a part. Mr. Chaudhury, learned the senior counsel, Ken Chaudhury, learned senior counsel, has completed his argument. Full stop. As due to problem in connection, Mr. Chaudhury, I Chaudhury, learned senior counsel, could not be properly heard as he is appearing from Itanagar bench. So he is appearing from Itanagar. Full stop. Accordingly, list this matter for concluding argument of Mr. Chaudhury on so and so day after. As part heard.
Alright.
Will these days this is the last matter. We will not hear longish matters for next.
In any case, next week is the most miscellaneous.
Most miscellaneous.